शिरोदिनि वासिनि विष्णुविलासिनि जिष्णुनुते भगवति हेशिति कण्ठकुटुम्बिनि भूरि कुटुम्बिनि भूरि कृते जय जय हे महिषासुरमर्दिनि रम्यकपर्दिनि शैलसुते सुरवरवर्षिणि दुर्धरदर्शिनि दुर्मुखमर्षिणि हर्षरते त्रिभुवनपोषिणि शङ्करतोषिणि किल्बिषमोषिणि घोषरते धनुजनिरोषिणि दितिश्रुतरोषिणि दुर्मथतोषिणि सिन्धुसुते जय जय हे महिषासुरमर्दिनि रम्यकपर्दिनि शैलसुते जय जय हे महिषासुरमर्दिनि रम्यकपर्दिनि शैलसुते जय जय हे महिषासुरमर्दिनि रम्यकपर्दिनि शैलसुते
Hi guys, thank you for joining the live stream. Let me know if the audio is coming fine or not. So today we are going to be discussing the Indian state, Indian province of Bangladesh, which masquerades as a temporary country and is a fake country essentially, which will soon be back in the Indian map sooner or later in our lifetimes or not. So we are going to discuss the Enemy Property Act of that country, now called Vested Property Act or something. This is a research paper written by the fantastic Dr. Taslima Yasmin of Dhaka University. She did her PhD from Brunel University in London. Now, we are of course discussing Bangladesh in the safe, secure manner that we usually go about in this channel, because of course the places all of us are from and the places and essentially you all know what I'm talking about. So even then, why do we have to discuss Bangladesh at the moment? Because now spiritual leaders from groups who have forever and ever and ever, let's say, forwarded their best foot forward in their attempts to collaborate with other religions with the end goal of benefiting mankind. And groups now, basically the group we are talking about, has been accused of being too friendly, too accommodating of other religions. That group, a spiritual leader from that group, is getting unfairly arrested, and of course riots are breaking out, as one of our viewers are talking about here. Abir Zain Patel, converted to Guju from Bengali, he is saying that the riots are breaking right now in Chittagong over alleged killing of an advocate without any proof. Yeah, so false flag operations. So stay safe, Abir Zain, Abir. The Enemy Property Act was abused by left, right. Yeah, of course. A version of that exists in India called the Waqf Board Act, or I think it's an act. So Starling Tech is asking what are your opinions on Indian NRIs, liability or asset? They can be both, because just like any other group, there are different kinds of people in those groups as well. Not to digress anymore, we are now going to discuss this paper. The enemy property laws in Bangladesh, grabbing lands under the guise of legislation. When we are done with such laws in India, then these laws from Bangladesh will also be destroyed by us. But first we need to destroy such laws inside India. Let's start now. Let's see what are her findings. This paper is from Rutledge, Taylor and Francis Group, of course. Oxford University Commonwealth Law Journal. Dr. Taslima Yasmin, Department of Law, University of Dhaka, Dhaka, Bangladesh. The abstract says, the law of enemy property has a long and complex history in Bangladesh. Although it originated from the emergency laws promulgated during the India-Pakistan War in 1965, its legacy continued in independent Bangladesh till recent years. See, this is the problem. This is the argument that libertarians have forever had against this excuse of emergency, okay? Emergency not as in any specific event in history, but the concept of emergency from the side of state authorities, that अभी के लिए थोड़ा एक टेम्पररी जरूरत है, अभी के लिए थोड़ा कुछ हमको चुतिया लॉज बनाने दो, उसके बाद ट्रस्ट मी ब्रो, ट्रस्ट मी, आफ्टर द इमरजेंसी इज गॉन वी विल कैंसिल ऑल ऑफ दीज लॉज, वी वोंट कीप एनी ऑफ देम. या we know why we can't bring more accountability in the judiciary today when those laws changed, and the same problem we see here. So emergency laws promulgated during the India-Pakistan War in 1965. Its legacy continued in independent Bangladesh till recent years. The law, however, did not itself encourage any encroachment of property rights. Rather, it has been misused by different political regimes to legalize the unlawful benefits accrued to influential land grabbers under the pretext of enemy property. This study, through a historical review, draws a legal analysis of how the process of taking over enemy properties by the government authorities had no legal justification and was used merely as a technique to deprive religious and indigenous minorities of their lawful property rights. The study also scrutinizes the present law, which promises to return the properties and attempts to look into the reasons behind its failure to make effective returns to the lawful owners. Now, this idea that uh, influential land grabbers. Now, this reminds me, remember Gandhiji's argument that all the reasons for all the riots between Hindus and Muslims, or Muslims and any other minorities in Bangladesh forever, have been a bunch of poor, landless Muslims fighting against evil capitalist Hindus. Meanwhile, rich capitalist influential land grabbing Muslims are using the law to take away lands of poor Hindus. No Gandhiji to see this day. And so, an introduction. The legislative history of the law of enemy property in Bangladesh has a multifaceted background. It would not be an overstatement to describe it as one fashioned heavily by political influences and regime changes. From martial law rulers to democratic political leaders, the laws surrounding enemy property have experienced different dimensions at different times and always provided grounds to the government authorities for illegally interfering with the property rights of citizens, one of the prerequisites of a modern nation state. More precisely, of the Hindu minority citizens. The enemy property laws served as a powerful instrument in the hands of the government machineries for the gradual marginalization of not only the Hindu community, but also of other religious and ethnic minorities, including indigenous people. Barkat, the famous Professor Barkat, of course, who pointed out that approximately, I think, 630 Hindus leave, or minorities leave Bangladesh, running away from religious persecution each and every day, and there won't be any Hindu left in Bangladesh in, I think, by 2030 or 40. That's the statistic he says. Barkat finds that about 1.5 million households, over or 7.5 million people representing religious and ethnic minorities, of which 80% were Hindu minority, and Hindu minority in Bangladesh means mostly lower caste Dalits. Okay, so 80% were Hindu minority, have been directly affected by the enemy property laws during different political regimes. They have lost over 3 million acres of their land, of which 87% belong to the Hindu community, and many other movable assets. This paper finds it pertinent to begin with a short background of the political regime changes in Bangladesh. The paper will then focus on the core issue of the study of chronologically analyzing the laws that govern the issue of quote unquote enemy property in the subcontinent, and the politics behind keeping those laws alive after the emergence of independent Bangladesh. Okay, and that's of course something that never goes away. Okay, that's the nature of state. That's the nature of state power. That's the nature of power. Even you give it an excuse to be a fucking pit bull, it will be a pit bull. It is power is always pit bull. Okay, it depends on you whether you will love it, caress it, feed it, tie it up, or will you unleash it upon yourself, or will you unleash it upon people you hate. In so analyzing this important legislative background, the two questions that the study attempts to discuss parenthetically are: first, whether the Bangladesh government had acquired full ownership of over the properties that it had received from former West Pakistan, thereby extinguishing all entitlements of the original owners, and secondly, whether the Bangladesh government could take over new properties on the basis of laws that were effective during the India-Pakistan War of 1965. Eventually, in analyzing the current state of affairs of administration of the enemy properties, The paper will scrutinize the current act, the quote unquote Vested Property Return Act of 2001. 2001, okay, remember, one of the biggest genocides of Hindus again in Bangladesh, that deals with the return of these properties to their original owners. Although this paper does not aim to suggest or formulate any substantive recommendation addressing the illegalities surrounding this issue, it does make a conscious effort to look into the real intention of the lawmakers and to indicate why there has not been any effective return of such properties as yet. Political regime changes in Bangladesh. With the independence of India in 1947, British colonial rule came to an end, and this was followed by creation of the two successor states, India and Pakistan. This partition on the basis of religion of the majority inhabitants is historically known to be the outcome of the two nation theory, which asserted that Hindus and Muslims in the Indian subcontinent form two different nationalities based on religion, irrespective of their ethnic, cultural, or social unities. First proposed by Sir Syed Ahmed Khan, who criticized Muslims for taking part in the revolt of 1857, which was condoned by Veer Savarkar, who is then blamed for coming up with the two nation theory. How weird is the writing and learning of history in India? In 1971, Bangladesh, being the east wing of Pakistan, known as East Pakistan, liberated itself through the War of Liberation to achieve its cultural, geographical, and economic freedom against the exploitative and discriminatory policies of the former West Pakistan. But what actually was going on in their minds was that ये डिस्क्रिमिनेशन हमको पसंद नहीं है, हम डिस्क्रिमिनेशन करेंगे, हम प्रॉपरली डिस्क्रिमिनेशन करेंगे। यहाँ पे तो हम भी थोड़ा साइड इफेक्ट खा रहे हैं डिस्क्रिमिनेशन का, हमको अकेले डिस्क्रिमिनेशन करने दो, मेरे को आता है प्रॉपर डिस्क्रिमिनेशन, लिव दिस अप टू मी, ओके? Like when CIA takes up a job from maybe some other junior law enforcement body, and the seniors in the suits come and say in every movie that thank you, we'll take it from here. So that was Bangladesh's attitude essentially, that okay, y'all negotiated partition with India and stuff, thank you, now we'll take it from here and we'll show you what discrimination truly is. Learn from us. After independence, Bangladesh started its journey as a new sovereign under the political leadership of Sheikh Mujibur Rahman, the protagonist of the 1971 War of Liberation and the leader of Awami League, the political party which was at the forefront of Liberation War, and thus began their second attempt at pretending to be a country. As one of the main triggering factors of the movement against former West Pakistan was its oppressive policies based on religion, Bangladesh naturally started its journey with secularism as one of its fundamental state policies. However, there's always a however here. So, however, the Mujib regime was abruptly brought to an end with his brutal assassination along with most of his family members on 15th August 1975. So 4 years of pretending to be a nice different country, and they fall flat 4 years later by a group of army officers. Capitalizing on the existing public mood, which was increasingly keen on adopting Islamic values. Okay, so where did the idea of secularism even come from? Did Mujib randomly conjure it up out of his ass? Or are the rumors then true that Mujib was never a secular himself, had no intention of doing any such thing himself? Because otherwise, why would a politician randomly use an idea like secularism to rule when he could have been an Islamist that he is accused of being and run the country any way he wanted? So unless Islam was actually popular and unless he was not an Islamist, it was all a lie to begin with, right? Maybe just to get India's help, maybe just to get some benefits out of UN. So you see, the idea that Mujibur would have run a secular Bangladesh was a lie to begin with is proven by the fact that the country wanted Islamism, but they didn't want Pakistan. So there was no love for Bangla Bhasha to begin with. It was never the case. So capitalizing on the existing public mood, why is this public mood in favor of Islamism and not secularism? And if so, why did Mujibur Rahman, even if he was a secular, how did he dream that he could run a country full of people who want an Islamic country? How would he run them based on secularism? How did he conjure up this idea? How was he going to do this? With complete insane dictatorship, right? And that's never going to be possible. Bangladesh is pretty big, unless you're ready to kill every Islamic you set your eyes on, which he was not going to do. But that would mean 90% of Bangladesh dies, maybe. So what was his plans from the very beginning? That I won't even try to do secularism. Let's just use the word secularism to fool dumb fucks in India. So capitalizing on the existing public mood, which was increasingly keen on adopting Islamic values. Okay, fool dumb fucks in India and then create a cottage industry of talking about the 1971 war and Bengali language itself in Kolkata. Capitalizing on the existing public mood, which was increasingly keen on adopting Islamic values, the coup leaders used Islam to legitimize their position, and thus, with the change of regime, secularism had overtly begun to fade away. We could argue it was never there to begin with. Following a number of military coups, Major General Ziaur Rahman, who was the chief martial law administrator of the immediate past military regime, became the president of Bangladesh on 21st April 1977. Zia was a revered freedom fighter. Freedom from Pakistan to do discrimination properly as they wanted, not the way Pakistan wanted. Zia was a revered freedom fighter. They just didn't want to give cut money to Pakistan in their efforts to discriminate or oppress Hindus. Zia was a revered freedom fighter and they just cut out the middleman. Zia was a revered freedom fighter and was awarded Biruttom, the second highest military honor and the highest for living officers by the government of Bangladesh. However, in his effort to secure support from the majority of the population, Zia adopted a new model of nationalism being distinct from that of Sheikh Mujib, emphasizing upon Islam as a religion instead of endorsing secularism. Oh, so surprising. By the proclamation of Order Number 1 of 1977, the ideal Bismillah Rahman Rahim, in the name of Allah the Beneficent, the Merciful, was inserted at the beginning of the Constitution above the preamble. Through the same proclamation, secularism as one of the fundamental principles of state policy, as was enshrined in the 1972 Constitution to fool Bengalis of Kolkata and Indian Government of India leadership in Delhi, was substituted by the principle of absolute trust and faith in the Almighty Allah. In 1979, the Bangladesh Nationalist Party, BNP, which was formed by Zia, had evolved as one of the two major political parties in Bangladesh and won the parliamentary elections with more than 2/3 of the seats. We are supposed to believe that the nation was secular. Any important footnotes? Doesn't seem so. In 1978, dystopian land is saying India ने ही उनको secularist का certificate हाथ में पकड़ा दिया था. Yeah, it was like a roadies audition के तू है secular, तू है, तुझे पता नहीं है तू secular है, तुझे मैं बोल रहा हूँ तू secular है. হয় জানতে পারো না তুমি secular তুমি জানো না. In 1978, Zia appointed Hussein Muhammad Irshad as the new chief of army staff, promoting him to the rank of lieutenant general. On 30th May 1981, President Ziaur Rahman was assassinated by a group of military officers. Lol. Thus begins another era of bullshitting their way through the world, pretending to be a country. His successor, Abdus Sattar, who was forced out of power on 24th March 1982 by another military coup led by General Irshad. By the way, remember, guys, for those non-Bengalis joining our live stream for the first time, do you all know that Sheikh Mujibur Rahman's killer lived with a completely fake identity in the place called Park Circus in Kolkata up until like last 3-4 years back, as far as I remember. I think he got arrested in 2014 or something. Okay, just check Google once, or if someone knows can clarify here in the comment section. Nino is saying India may have been more insistent on branding them as secular than they themselves. Yes, of course. Winnie the Pooh, the famous character from Thakumar Juli, is saying that convert to Bengali from Dhokla. His successor, Abdus Sattar, was forced out of power. Yeah. So in 1986, Irshad formed the Jatiyo Party, a state-sponsored political party, and won 2 consecutive parliamentary elections in 1986 and 88, although results of both the elections were alleged to have been heavily manipulated. Irshad was said to have accepted the Bangladeshi model of nationhood, but had made it more rigid and totalitarian by giving it a totally Islamic orientation. I don't get this. The country, the public mood in the country is allegedly Islamic. The secular guy wants to do democracy on a country which is Islamic. Now, a guy who wants to be Islamic wants to run the country dictatorially. क्यों भाई? तुमको डिक्टेटर, तुमको टोटलिटेरियन बनने की क्या जरूरत है? Are these guys dumb? Okay, you can run it in an Islamic way, even with democracy, unless it's prohibited in some way in your scriptures, of course. So this is the future of for India that many people in Kolkata want. So Irshad was said to have accepted the Bangladeshi model of nationhood, but had made it more rigid and totalitarian by giving it a totally Islamic orientation. It was during his regime that Islam was declared as the state religion. See, this is the obsession with centralization. Some systems just cannot survive without absolutism and centralization. Uh, just to be fair, we can say that yes, it's an ideology that was born in a desert, where of course the way of living is very different from how you live in a land, in a fertile land uh, where you have a nicer life than the fucking desert, of course. But you see, they go on exporting that ideology everywhere, and have not moved on from it. Uh, of course, Christianity also went through some Renaissance, Reformation, etc. Maybe that era has not come because it's much younger than Christianity. The idea is that, again, getting back to Nietzsche, the love of irony is a sign of good mental health. The obsession with absolutism is a sign of pathology. And with the obsession of pathology, with the obsession of absolutism, comes everything else. The obsession with centralization, the obsession to control everything, and the idea that रात को खाना खिला दो बाबू को, नहीं तो इविल कैपिटलिस्ट आ जाएगा, बाबू को और नौकरी दो, बाबू को और घूस दो, नहीं तो इविल कैपिटलिस्ट आ जाएगा. These are the kinds of things, are the kinds of people who believe in these things, who have an obsession with absolutism, who are absolutely mentally ill. It was during his regime that Islam was declared as the state religion. Irshad continued to occupy state power until 6 December 1990, when he was forced to resign after a popular uprising involving participation from all major political parties. So, another one bites the dust, and someone else is now going to pretend to run this fake country. In 1991, parliamentary democracy was restored, and BNP, led by Begum Khaleda Zia, who passed out from Surendranath College in Kolkata, wife of the late President Zia, was elected to be the prime minister. Khaleda Zia is the one from Surendranath, right? Guys, again, please Google and confirm. As far as I remember, she is a pass out from Surendranath Bongobandhu, Surendranath College of Kolkata. And Surendranath Banerjee, again, for those of you who don't know, once said that because moderates of those eras did not believe in the idea of freedom, Surendranath Banerjee went a step ahead and said that not only do I not want partition, not only do I not want independence, in fact, anyone who demands such an idea like independence should be put in asylums. Khaleda Zia ने क्या क्या टेररिस्ट दिए हैं, और कोलकाता ने क्या क्या टेररिस्ट So, okay, she was married when she was in class 8. That's why I'm thinking, how could she be the wife of Ziaur Rahman? I thought she was a daughter, lol. So anyway, in 1991, parliamentary democracy was restored. The Awami League, headed by Sheikh Hasina, one of Mujib's surviving daughters, won the succeeding election in 1996 and lost again to BNP in 2001. She lived only because she and her sister were hanging out in Germany. After massive political discontent, followed by the resignation of BNP in late October 2006, the subsequent general election was finally held on 29 December 2008 under the regime of the caretaker government. Caretaking of what? Caretaking of the Indian state of Bangladesh, temporarily masquerading as a country. Awami League won with a 2/3 majority in the elections, and Sheikh Hasina assumed the office of the Prime Minister from 6 January 2009. In 2014, the 18-party opposition alliance led by BNP boycotted the national election, demanding that the election take place under a non-party caretaker government, which proviso was abolished by the Awami League government in 2011 by the 15th Amendment to the Constitution. The 2014 general election took place in the absence of BNP, and the Awami League formed the current government for a second consecutive term, led by Sheikh Hasina as the prime minister. And that's when Hindu fascism and evils of capitalism started flourishing in India, their neighboring country, which is why 2014 onwards, Bangladesh made sure that none of their poor people poor hungry people have to illegally escape to India and suffer the consequences of the rise of Hindu fascism and rising income inequality. That's what they did. Since 2014, there has not been a single illegal immigration from Bangladesh, just because they want to survive in the better country called Bangladesh, where there is no rising income inequality and rising Islamophobia and rise in Hindu fascism. With this brief description of the different political regimes in Bangladesh in the backdrop, the following sections focus on the issue of enemy property in Bangladesh and its legislative history. Okay, the legislative history of enemy property. Now I'll check some comments and a bit of green tea. Indian political TV is saying she was just 8 pass. Khaleda Zia never joined college. I don't think so, unless I'm mixing her up with her father, of course. Let me just check Wikipedia. Did you all check Wikipedia? Party, succeeded by, preceded by, succeeded by, preceded by, succeeded by, preceded by. My God, how many times has she been succeeded and preceded? Involvement in politics, birth date, honors, electoral history. Okay, if she didn't go to Surnath, maybe her husband did. That would be even more hilarious. Winnie is saying, haha, Winnie the Pooh seems to be famous in College Street, Kolkata. My comments are often screenshotted and posted, which I never expected. Oh, it's not screenshotted, since you seem to prefer English over every other Indian language. It's called screenshot. Shooter past tense holo shot. So it can't be screenshotted, bro. She was married. Okay, let's see some other comments. Sandeep Kumar Munda is saying the test of Bangladesh failing secularism is rejoining India post freedom from West Pakistan. BD is the intersection of Islam and Bangla feudalism and economic liberation of. Okay, Mujib was a part of student wing of Muslim League. Yeah. The legislative history of enemy property has been described by researchers and rights activists as one having deep-rooted consequences for the Hindu minority. It evolved as an outcome of a series of discriminatory laws promulgated by the Pakistani rulers to provoke communalism in East Pakistan by instigating a systematic, forced out-migration of the Hindu population to India. One such legislation in the post-partition period was the East Bengal Emergency Requisition of Property Act 1948, which had legalized the temporary and permanent appropriation of private properties on the pretext of an abrupt and emergent demand for accommodation for numerous public administration offices in the eastern province of the newly created Pakistan. Now, I had an uncle, okay, who, whenever he got into street altercations, street rage, car rage, okay, some little altercation of words breaking out between two people based on how one was driving or where one has parked, etc. Whenever such an altercation took place, that uncle used to say, দেখুন ঝামেলা করে কি হবে, আপনার মন্ত্রী আপনারও চেনা আছে, মন্ত্রী আমারও চেনা আছে, তার থেকে এখানেই সামলে নি, আর বেশি কথা না বাড়িয়ে. So he used to say that, see, even you know some minister, I know some minister, so let's not escalate with fist fights or loud voices, etc. Let's just decide what do we want right now out of this situation. What a calm way to judge things. So you see, this is what people forget. This is what everyone in every country forgets, especially the dumb ones, that मंत्री तुमको भी पहचान वाला, तुम्हारा चाचा भी कोई है होगा विधायक, हमारा चाचा भी कोई होगा विधायक, निकल ही जाएगा कहीं ना कहीं ढूंढने से, ओके, और या एटलीस्ट क्वाजाई चाचा एडजेसेंट कोई निकल ही जाएगा, ठीक है. तो तब क्या होगा जब तुम्हारा चाचा नहीं रहेगा, ओके. टुडे आई वाज डिस्कसिंग Trump's idea of not even allowing a transgender person to write their gender, okay, in any official document. They have to write their birth gender, okay, which is, I think, a step too far even from a freedom of speech standpoint. You don't have to highlight this or promote this or incentivize this the way it was going on up until right now. But now Trump is not going to even let them claim to be even a trans woman or a woman. They have to write they were a guy. So ठीक है, all corrections are over corrections in history. That is what people forget. वोक्स को लग रहा था कि उनके चाचा विधायक विधायक है तो अब हमेशा ही उनके चाचा ही रहेंगे विधायक। अब तो किसी और का चाचा आ गया है। अब भोसरी के तुम आइडेंटिफाई करना तो छोड़ो, ड्रेस मतलब नंगा नाच स्कूल में करना छोड़ो, अब तो तुम अपना अपना ये न्यू जेंडर लिख भी नहीं पाओगे। ओके, दिस इज द आइडिया अगेन what is happening in Bangladesh. What if someday someone learns from Bangladesh about these laws, okay, and ends up applying them here on someone else? Or the idea that some Hindutwadi socialists have been debating me on Twitter that you see the talking to Elon Musk directly that you see that the stuff you are talking about, firing of babus and stuff, these have major consequences once you guys are out of office. Once Trump goes out of office or Elon Musk is out of office, then it will have dire consequences for the country. On the other hand, you all must learn from Narendra Modi on how to do socialism well, how to keep capitalists in check. Okay, so as a solution for that, let's hire more babus. Let's imagine that we'll hire another babu to make sure the previous babu works hard, and the second babu we hired to do oversight, we'll hire another third babu to do oversight on the second babu. Then we'll hire a fourth babu to do oversight on the third babu. And ऐसे ही भोसरी के हम सब बाबू ही बनेंगे चूतिए, because I don't have brains, because I'm just a socialist who just hates other socialists because they have green and purple hair. But I am a socialist and I don't like to admit it. That's the way they think. So their argument is that Narendra Modi will never go out of power. He is immortal. Elon Musk is mortal. Trump is mortal. What will happen to the babus or the country when evil capitalists take over the country after Elon Musk is out of power? But nothing will happen to the country when power is centralized as fuck and babus run the country and Narendra Modi is out of power. Okay, that's the brains of socialists in general, and to be specific here, Hindutwadi socialists. So again, in the context of massive out-migration of Hindu population on account of communal disturbances in the post-partition period, the East Bengal Evacuees Administration of Immovable Property Act of 1951 was passed. They have creativity in two things: coming up with bullshit excuses to call their Indian state a country, and come up with newer and newer and newer acts to take properties of Hindus. Because you see, as according to Gandhi, they were the poor landless ones who stood up against Hindu capitalists. Through the Evacuee Property Management Committee, the government was authorized to take charge of evacuee properties with all rights and powers of the original owners. This also created ample opportunities for the government functionaries to unjustly take over properties belonging to Hindu citizens. Properties belonging to the Hindu elites and zamindars were mainly affected by this act. In January 1964, the holy hairs of the Prophet Hazrat Muhammad were stolen from the holy shrine of Hazrat Bal in Srinagar, which instigated a communal riot in the then East Pakistan. After 6 months, the East Pakistan Disturbed Persons Rehabilitation Ordinance in 1964 was promulgated for the speedy rehabilitation of persons affected by this civil disturbance and for protecting the immovable properties of the minority community in the then East Pakistan. अच्छा, तो श्रीनगर में बवाल हो गया, इसलिए बांग्लादेश में लॉ हो गया कि अब चलो थोड़ा लैंड हड़पते हैं हिंदुओं से. क्या जीनियस 4D चेस है. However, with this apparently innocent purpose, innocent, absolutely. भोसरी के एक 12 साल का लिबर्टेरियन बच्चा भी बोल देगा कि ये इनोसेंट नहीं था. However, with this apparently innocent purpose, the ordinance in fact restricted the right of transfer of immovable properties belonging to the minority community by requiring that before any such transfer can be made, prior permission from the competent government authority must be obtained. Thus, as Barkat, the genius Abdul or Abul Barkat, professor of Dhaka University, as he notes, the straightforward consequence of the 1964 ordinance and associated processes and mechanisms was that the property rights of the minority community in Pakistan were severely curtailed by the state authorities. In this backdrop of legislations in this context and state practices of disfavoring the Hindu community, a war broke out between India and Pakistan on 6 September 1965 over the status of the state of Jammu and Kashmir. All the while, when Bengali Hindu leftist intellectuals in Kolkata were going on writing books after books after books on how partition happened because there was blame to be shared on both sides. Okay, দুপক্ষেই দোষ ছিল, or এই মৃত্যু উপত্যকা আমার দেশ না. Of course they will go to the mrityu potakas, that is their desh called USA. And then that Bangladesh is full of just our brothers in blood, and the unifying factor is the Bengali language. So, emergency was proclaimed by virtue of Article 31 of the Pakistan Constitution. In order to meet the emergency on the same day, the Defense of Pakistan Ordinance 1965 was promulgated to provide for special measures to ensure the security, public safety, and interest and the defense of Pakistan. By this time, of course, as far as I know, their first law minister, the fierce fighter for Dalit rights, Jogendranath Mondal, had fled Bangladesh, leaving behind all his followers, the gigantic numbers of Dalits in Bangladesh who still up till this date live there. And they will hopefully continue living there until the day we take that country back. Now, Jogendranath Mondal comes back and says that what's the point of Dalit politics here? Congress is doing a good job. Dalits have been emancipated. Casteism has gone away. And of course, I spoke to Dr. Shekhar Bandyopadhyay about this as well. He said that, yes, he said that at one point, but later on he did try to rejuvenate the politics again. But at one point he did feel the need to say this, that yeah, Congress has solved casteism. Abdul Barkat, he's the one who said through his research paper that every day average 600 Bengali Hindus leave Bangladesh, right? Okay. Why do you call Bangladesh an imaginary state? Not opposing, just asking reason. Because it was stolen away from us without our consent. Okay. See, if you are the head of a nation, you can't sell your nation. If you are the, let's say, father or mother in a family, it does not automatically give you the rights to sell off your children. So in that way, Indian land was not Congress's to give away. It was not theirs to consent upon. They were not supposed to say yes on any account. They were supposed to fight tooth and nail and go on opposing it at any cost. Okay? So we apparently the moderates of Congress fought for independence, right? So you could have fought for a few months more and explain to the British that no, whatever land we have right now, that entire country is going to be India. No, instead they decided on behalf of the entire country based on the demands of one religion. That is not acceptable legally or morally. Because first of all, who's asking for partition? One religion. Hindus didn't ask for partition. Buddhists didn't ask for permission. Keralian Jews didn't ask for partition. Sikhs didn't ask for partition. Jains didn't ask for partition. Nobody asked for partition. One side asked for partition. People pretending to represent everyone else said that, okay, push has come to shove. Let's give it away. It was not theirs to give away. It's been stolen from us by someone, with the help of someone pretending to be our guardian. So it's a temporary state. It will be taken back. In exercise of the power conferred by Section 3 of the Ordinance, which authorized the government to make necessary rules to meet the emergency, the Defense of Pakistan rules were framed on 6th September 1965. They make so many laws. Who the fuck is going to follow those laws? 4 years later, there's going to be another independence and someone's going to write a new constitution. Why do they even bother about writing so many laws? Just say, see, bro, I'm just going to be a dictator for 3-4 years. Let's just chill. Let's just go home. I'll run the country however I feel like in the morning. What's the point of hiring so many lawyers, writing down constitution and stuff? No one even can spell the word constitution in our country. The terms enemy, enemy subject, enemy firm, and enemy property had been defined in Rule 169, which essentially referred to either nationals or residents of India and their businesses and properties in Pakistan. Is that the finishing move of Rey Mysterio? Oh, that was 619. Lol. Under Rule 182.1, the central government was authorized to appoint a custodian of enemy property and to vest in him or her the management of those properties by appropriate orders, which will be turned over 4 years later. In exercise of this power under Rule 182 by 182.1, The Enemy Property, Custody and Registration Order 1965 was promulgated on 9 September 1965 to define and limit the nature of the rights and powers of the custodian of enemy property. Now, another subchapter begins. Vesting of enemy property is under emergency laws, whether it exhausted all rights of the original owners. Okay. In that case, even Pakistan has the same logic to go by. Yes, of course. We will just keep a buffer zone with Afghanistan. कुछ कुछ जगह हमको भी नहीं चाहिए भूसी के बांग्लादेश के साथ एक एडवांटेज है कि इट्स नॉट लाइक द कंट्री बियॉन्ड बांग्लादेश इज दैट बिग ऑफ अ प्रॉब्लम विद अस देयर मे बी सम द स्टैंडर्ड जियोपॉलिटिकल प्रॉब्लम्स एंड स्टफ बट विल कीप अ बफर जोन someday even when we get Bangladesh. Okay. The history of enemy property laws had in fact started with the vesting of enemy properties to the custodian under Rule 182(1) and the subsequent orders. However, the vesting did not by itself give absolute ownership over those properties to the custodian or to the government. This is an important question in the enemy property discourse, which has also engaged the judiciary subsequently in deciding whether the government authorities were restricted from usurping full ownership of the enemy properties seized during a war. Under the general principles of law, the legal implication of such vesting was that the authority concerned could exercise right of possession in respect of the property during the period of emergency and would eventually restore the possession of the said property to its owner on cessation of emergency. Yes. Unless there was any other law providing for a contrary arrangement. See, this scholar, Dr. Taslima Yasmin, is writing in a way that makes us think that there are laws and stuff. There's a judiciary, there's a legal procedure in Bangladesh. These are just random, made-up, temporary laws which won't stick for more than 4 or 5 years because another dictator will come and make up absolute random rules that he pulled out of his ass. Okay, none of these things matter. She is playing cricket and the Bangladesh governments are playing checkers. This is not the same sport we are talking about. This position is also in accord with the academic literature concerning enemy property in the post-World War I and II period, which had almost unanimously considered the practice of permanently retaining private enemy properties, exhausting all rights of the original owners, to be a redundant right, of course. A similar conclusion on the non-exhaustiveness to the original owner's rights can be drawn from a literal interpretation of the relevant emergency laws enacted in the context of the India-Pakistan war. Oh, the total viewers right now watching is 71, combining Twitter and YouTube, okay? This is a nice number to have. 71. When for the second time, this province of India called Bangladesh started their games at pretending to be a fake country. Laws enacted in the context of the India-Pakistan war. In the original text of Rule 182(1) of the Defense of Pakistan rules, the purpose of vesting enemy properties to the custodian was stated to be for, quote-unquote, preserving enemy property in contemplation of arrangement to be made at the conclusion of peace. 4 or 5 words which are not applicable for Bangladesh. This was re-emphasized by Section 4(1) of the Enemy Property Custody and Registration Order 1965, which authorized the custodian to take only such measures in respect of a property vested in him as were necessary for preserving the property. See, the number of lawyers they hired or the amount of money these people spent on their education just to come up with these terms and write these laws when they were not going to follow any of them anyway, would have actually, if they were invested in entrepreneurship in their country, it would have probably not led so many of their people to jump through rivers and swim through rivers and come up to a country which has rising income inequality and rising Hindu fascism and rising Islamophobia. Although by that same provision or proviso, the custodian had the authority to dispose of the property. That authority could only be exercised if such disposal was necessary for the overall purpose of preservation of the property. Again, on 8 January 1966, the East Pakistan Enemy Property, Lands and Buildings Administration and Disposal Order was promulgated by the governor of East Pakistan with similar purposes as the 1965 order. Provisions of this order also gave a similar idea as to the nature of the rights of the original owner over the property so vested during emergency. In particular, Section 3, Clause 3 clearly stated that the custodian shall take such measures as may be necessary for the management and protection of the property. Protection from whom? By an amendment to Rule 182 on 2nd November 1965, the expression quote unquote preserving enemy property in contemplation of arrangement to be made at the conclusion of peace was replaced by a new expression, hiring another lawyer, money which could have been spent on entrepreneurship. Quote, to provide for the administration and disposal by way of transfer or otherwise of enemy property. End quote. However, this did not change the overall purpose. Oh, I see. So surprising. Lo and behold, this did not change the overall purpose of such vesting, as the relevant provisions of the Enemy Property Custody and Registration Order 1965 remained unchanged. Lol. Hence, the custodian continued to be under a legal duty to preserve the property for the original owner, and there was no apparent change in the status of the rights with which the property was vested in him. Thus, the whole idea underlying all those rules and orders was to preserve and protect the properties until the war was over. Ah, protect, provide, preside. They were clearly emergency legislations promulgated from a defense perspective, and they could not be interpreted as giving away full ownership of the property to the government. Oh, acha, even though a 12-year-old libertarian could have understood this problem. More so, if the intention of the lawmakers was to extinguish rights of the original owners, this could have been clearly stated in the provisions. However, no such express reference can be found in any of the relevant laws. Lol. Thus, it was rightly held by the Supreme Court of Bangladesh in Binoy Bhushan versus SDOB Badia or Boria that the right which accrued to the deputy custodian or assistant custodian by virtue of the vesting in consequence of the order made under Rule 182 1B was no longer right than that of protection and management of the property, the benefit of which would ultimately rebound to the credit of the enemy owner. Again, the judge is playing cricket, the politicians and the general masses are playing checkers, and they say, who gives a shit? It is important, however, to note that although legally, vesting of the properties was done only to safeguard national security of Pakistan in a war situation, in practice, the orders of vesting of enemy properties were not devoid of the anti-secular ethos of the then existing state policies of the Pakistan government. Oh, so surprising. Who could have known? Some of the government circulars issued by the Office of the Custodian of Enemy Property bear such reflections. For instance, in a circular of 1966, issued in the context of taking over possession of enemy property as per the East Pakistan Enemy Property, Lands and Buildings Administration and Disposal Order 1966, it was clearly stated that properties in which majority shares belonged to Indian Muslims would not be treated as enemy property because they are not our enemies. It was even stated that where the majority of shares belonged to non-Muslim Indians, shares of Indian Muslims therein would not be treated as enemy property and would be given the same treatment as local shares. Another circular issued in 1968 stated that properties of Muslims residing in India would not be taken over as enemy properties unless such taking over became necessary for the protection of the interest of the absentee owner. The circular even mandated that those properties would be restored to the actual owners when they returned to claim their properties. Thus, even though clearly all the nationals of India and persons residing in India fell within the definition of enemy as per the emergency legislations, some of their properties were exempted from being taken over only on the ground that the owners were Muslims. Meanwhile, the scholars and judges are playing cricket. Could the authority of taking over enemy properties extend beyond emergency? No, দুপক্ষেই দোষ ছিল, কারণ এই মৃত্যু উপত্যকা আমার দোষ না. The actual war between India and Pakistan was short-lived and was formally over by a ceasefire declaration in the Security Council on 20th September 1965, which was accepted by both states. The ceasefire was followed by the Tashkent Declaration mediated by the former Soviet Union, where both the parties agreed to withdraw their respective armies from the disputed territory Jammu and Kashmir. Remember, we used to be the colony of Soviet Union until 1991. Nevertheless, the emergency proclaimed by the Pakistan government continued in effect till it was finally revoked on 16 February 1969, explicitly declaring that the grounds on which the proclamation of emergency was issued had ceased to exist. Consequently, the defense of Pakistan ordinance and rules had also ceased to have effect. However, what did I tell you? There's always a however. Lol. So the however has arrived, guys. Get ready now. Let me have a sip of tea before the however and let me check some comments. Rising, rising income inequality. USA was seeing record illegal immigration number few months back. You see, those illegal immigrants are not going there to work. They are going there to decrease the rising in income inequality. They are true socialists. They hate income inequality. They will go there and plead with the evil capitalists that please, please, please don't let this income inequality rise anymore. They are going there as peacekeepers. Think of Mother Teresa, missionaries of charity. Okay, so the illegal immigrants of Mexico or whichever country they are going from, they are essentially going there to do charity and to plead in front of the offices of evil capitalists that please don't increase this income inequality anymore. Buddhadev is saying actually Jogan Mondal's statement should be taken with a pinch of salt. Two reasons: the guy he said whatever got he said nothing happened in Noakhali. Yes, pinch of salt nahi, pura. You can pour an entire gamla of salt on his head on anything he has ever said. Even that would be right. Enemy property act in summary is if you have gone to India from Bangladesh or Pakistan and you are Hindu, then your property is government property. और ये एक सेंटेंस में जैसे हमारे भाई आबिर जैन ने बोल दिया, ये चुतिया सिर्फ यही तो करना है. इसके लिए कितना तुमको लॉ, ऑर्डिनेंस, सर्कुलर, ये एक्ट, वो एक्ट, 66, 69, 71, ये सब काहे चाहिए? इसके लिए तुम लॉयर हायर मत करो. सिर्फ सुबह उठ के बोलो सुनो, सब भोसरी वाले हिंदुओं का प्रॉपर्टी आज से हमारा, चलो अब काम पे निकलो. ये बोल देने से बांग्लादेश का एंटरप्रेन्योरशिप आई थिंक एनवायरनमेंट वुड इंक्रीज much more because they would not waste so much taxpayer money on lawyers formulating these bullshit laws. So, however, on the same day, the Enemy Property Continuance of Emergency Provisions Ordinance 1969 was promulgated to quote-unquote provide for the continuance of certain provisions of the Defense of Pakistan rules relating to control of trading with enemy. ट्रेडिंग भी नहीं करना है एनिमी के साथ, मगर एनिमी का रॉयल एनफील्ड चाहिए, एनिमी के साथ खेलना है क्रिकेट, एंड कंट्रोल ऑफ एनिमी फर्म्स and the administration of property belonging to them. Amongst the provisions that were continued by this ordinance were Rule 161, which defined enemy, Rule 169, which defined enemy property, and Rule 182, dealing with vesting and administration of enemy property. Relax Lead is saying that, but Dada, those who are going to the USA are going from countries even more unequal to than the USA. It's a case of relative inequality. Plus, USA has social support, which most immigrant countries lack. Relax Lead, are you new in our channel? That was a sarcastic comment. Yes, I was being completely sarcastic. And yes, in rise of income inequality is not a problem. If it was a problem, no one would go to USA. Because since capitalism has grown its most evil roots in USA, right? So there should be the highest amounts of problems from capitalism and the highest amounts of income inequality, which some people in academia pretend to give a shit about, whereas no one else actually does give a shit about, and then they go to USA. Okay, healthcare of Cuba is touted as one of the successes of a communist rule. Meanwhile, people from Cuba are crossing the fucking sea on rafts made with their hands and going to Florida to become an illegal immigrant, to become a refugee in USA. Okay, and meanwhile, when there is such brilliant healthcare in Cuba, so you see, what is the main problem here? What is the main problem with academics who say these things? What is the problem with socialists who get paid to say these things? What is the problem with babus who get paid to say these things? the common problematic factor among all these kinds of people is one single thing, that all of them are insulated from market realities. Okay, कैपिटलिज्म का क्या है, कोई बिजनेस का क्या है, कोई कोई सेल्फ एम्प्लॉयड आदमी का क्या है, कोई फ्रीलांसर का क्या है, हर रोज ईच एंड एवरी डे, ऑलमोस्ट ईच एंड एवरी मोमेंट, डायरेक्ट फीडबैक के how is the market accepting you as a business owner or as a whatever your profession is, as a musician or anything. Okay, every day you are getting that feedback, and every day you are altering your course based on those feedbacks. Okay, नहीं तो तुम नहीं रहोगे मार्केट में. Everyone else, the people I mentioned, they are immune and insulated from the market. Whether or not some people should be immune and insulated from the market is, of course, a different debate to have. I do believe some people, some kinds of scholars do need to be insulated from market realities, because let's say funding pure maths, funding theoretical physics, okay, things which are not going to give us genius innovations right here, right now. We may need to fund those kinds of academics for their entire careers, and maybe they'll go their entire lives without making any single important discovery. But it's still a benefit in the end, maybe not at the cost of everything else. Nothing has infinite value, but at least the countries who can afford it, who are in fact doing it, I think it's justified for them to do it, because someday that university might come up with a discovery which benefits not only their country but entire mankind. So some scholars, some niche group of specific scholars with specific duties can live a life insulated from market realities, just like Brahmins used to get land grants from Kshatriyas and Zamindars for this very reason, that तो सर आप घर बैठ के वेद पढ़िए, पढ़ाइए, पुराण लिखिए. अगर आपको बिजनेस में ध्यान देना पड़े तो back then तो there's no googling everything, you have to mug up every fucking thing. If you mug up everything in Gita, Mahabharat, Ramayan, Vedas, Puranas, how are you going to go about running your business? So you get a land grant where you maybe do a bit of farming, or maybe you hire someone else to farm, and hence here's your tenure. Okay, Brahmin land grants were essentially tenure tracks or tenures for scholars of today. The problem is there's too much of such people these days. There was once upon a time a problem of too many people getting land grants as well. Now, when so many people in positions of power and influence are insulated, protected, mollycoddled from the market realities for so long, for generations, and so hard, to such an extent, they are so far removed from the market, that's when they come up with this kind of bullshit that rising income inequality is a problem. Cuba has great healthcare, and there's rising Islamophobia, rising income inequality, rising Hindu fascism in Bangladesh. Meanwhile, illegal immigrants, poor illegal immigrants from a Muslim country are coming to that country. What in the fucking holy shit is going on? How can this be? Unless the claims of rising income inequality are absolutely horseshit. Either they are complete lies or they are absolutely unimportant, which I agree with the second part of the statement, of course, that it's unimportant. Income inequality rising is not a fucking problem. Why Ajit Bharti isn't aware of Bangladesh? He is though. By the way, did you watch Freedom at Midnight? No, I have only Netflix subscription. Jogover is being... Unfortunately, Navavimarsh is also right. Oh shit. The very name Bangladesh is an abomination, grammatically incorrect. Bangladesh, yes. By the way, guys, just to do a bit of self-promotion, keep an eye out for something called Vanga Sessions, starting out from my music channel called Nirajan Music, where we are going to attempt to revolutionize Bengali music once and for all. It's been a long time since Bengali music has been revolutionized. We are going to do some good stuff now, finally. Relaxed Lead is saying, stable inequality indices have stated that the US is doing much better for the state and level of its economy, but guess people at... Okay, let's continue with the paper now. Why is my WhatsApp open? What the fuck? I was wasting so much internet bandwidth up till now. Where's the PDF? Okay, let's continue now. This ordinance, another ordinance pe ordinance, raised an important legal question as to whether fresh orders of vesting properties to the custodian could be made after the revocation of emergency and cessation of the Defense of Pakistan Ordinance. This was particularly addressed by the Appellate Division Judgment of 1975 in Bangladesh Enemy Property Management Board versus Abdul Majid, where the court was of the opinion that since the provisions relating to vesting of enemy properties as well as definition of enemy property were continued by the 1969 ordinance, this implied that new properties could be taken over as enemy property under this ordinance, notwithstanding the lifting of emergency. The court emphasized that whether or not a property had fallen within the definition of enemy property depended upon the question of whether on the date of order of vesting, which in this case was 3rd February 1970, the state of war between Pakistan and India still continued to exist, and whether the owner of that property had migrated to India before that date. The court found that at the date of the concerned order, that is 3rd February 1970, even though emergency had been revoked, the state of war between India and Pakistan did not formally end, as there was no formal announcement of cessation of war. Accordingly, the court held that by virtue of the 1969 ordinance, the power of the enemy property authorities to take over properties was in fact extended beyond revocation of emergency. What a big surprise. However, this position was rightly contradicted in a subsequent decision of the appellate division, okay, again by people playing cricket. Meanwhile, the public and the politicians of Bangladesh are playing checkers. In Dulichand Omraolal versus Bangladesh, the court held that after revocation of emergency, quote unquote, there cannot be any supposed state of war or military operations which may be said to exist in the eye of law. Emergency was expressly proclaimed because there was a threat of war to Pakistan, and that threat, as the order of revocation of emergency itself stated, had ceased to exist on and from 17th February 1969. As such, the state of war had clearly ended and no further announcement was necessary. Thus, the court was of the view that by virtue of Ordinance 1 of 1969, although certain provisions from the Defense of Pakistan rules continued to be in force, it was done merely for the convenience of administering the properties that had already vested in the custodian during the war. It did not continue the power of the enemy property authorities to make new orders for vesting after the end of emergency. Okay, it did not continue that. Thus, the appellate division in the Dulichad case observed that by the 1969 ordinance, what was sought to be continued was the state of affairs which existed till 16 February 1969 as past and closed transaction. Accordingly, if any action was to be taken with regard to any property after 16 February 1969 as being enemy property, it must have vested upon the government only during the continuance of emergency, that is between 1965 and 1969, and not after that. This seems to be the right interpretation, as Defense of Pakistan Ordinance and the rules thereunder were simply emergency legislations, and it is only natural that with the cessation of emergency, these laws would also cease to operate. Ordinance 1 of 1969 merely continued certain provisions to govern those properties that had already vested to the custodian of enemy properties. This position had also found support in a subsequent decision of Sunil Kumar Ghosh versus the state. Also, although the Dulichad case had clarified an important aspect of the enemy property laws, it did create some level of confusion with regard to the need for an express order from the concerned authority before a property could be vested as enemy property. Thus, the Dulichad case held the view that if during the currency of emergency, that is 1965-1969, a property became enemy property, by fulfilling the conditions given in the relevant provisions of the Defense of Pakistan rules, it continued to remain so, even if there was no formal order or declaration from the relevant authority or no steps had been taken by them to take it over during emergency. Thus, subsequent taking over of such property would be permissible without any formal order of vesting or actual taking over of property. By holding this, the court had in fact given an undefined and unfettered authority to the government agencies to decide at any time whether or not a property could be characterized as enemy property. It leaves immense scope at the hands of the government functionaries. Oh, I see. It leaves immense scope. अच्छा अच्छा. हम तो सोचे थे कि सिर्फ मॉरल एथिकल लोग ही पावर में आएंगे. ये कैसे हो गया? It leaves immense scope at the hands of the government functionaries to unlawfully interfere with property rights of citizens by identifying new properties as enemy property during a time where laws relating to enemy property had already become redundant. This reminds me again the idea that Narendra Modi will live forever and after and will never go out of power and will always also have the same motivations and will never let babus run amok, etc. And kisi aur ka chacha kabhi vidayak nahi banega, that kind of view. A famous Hindutwadi YouTuber uh, whose work is mostly commendable everywhere, today I saw on Twitter, was asking for a goddamn ban on beer biceps. A ban on beer biceps. The most popular YouTuber in the biggest democracy in the history of mankind. Okay? Who has platformed so many people on the, let's say, arguably in pro India, pro Hinduism side, that he has been able to formulate discourse on these topics all over the world. And that guy should be banned apparently because he hosted one Dravidian historian. Okay. Also, of course, that guy, the host of Beer Biceps, pretty much admits that he is not an expert on anything, except when he debated Sandeep Balakrishna on how he was a great Hindu because he worships Lord Bhairava, and therefore he is an authority to speak on Hindu-Muslim anxieties. But other than that, he mostly says, I'm not an expert, which is why he has opened a podcast to invite experts to speak their mind. It's a fucking platform. It's not a mouthpiece of any one idea. And that guy apparently cannot have a Dalit historian, as if the government is really doing any fucking thing to counter any kind of anti-India history at all, okay? And you see, the fucking idiot who recommends banning beer biceps, what is he incentivizing the government to do then? Okay, not only do you not have to hire counter academics, okay, to counter Dalit, the not Dalit. I was going on saying Dalit. Okay, I meant Dravidian history. Okay, not Dalit history. So Dravidian history propaganda. You are not going to hire any academics to counter Dravidian propaganda. Instead, I just now am being demanded to do something which would be pretty easy to do for me technically. I would just delete Beer Biceps' channel from YouTube. Meanwhile, when someone else's chacha becomes Vidhayak, uses that as legal precedence to fuck all of your social media profiles, you fucking idiot socialist cunt. It's actually a guy, can't even call him a cunt. And we can't call him a cunt because he just lacks the depth that a cunt has, a literal cunt has. What a nut job. Namaskar Abhay. This observation of the appellate division was opposed by the High Court division in Sunil Kumar Ghosh case, where the court held that if during emergency there was no appropriate order of vesting under Rule 182(1)(b) of the Defence of Pakistan rules, no order of vesting or no step for taking over such property could be made after the state of war ends, inasmuch as such property had ceased to be enemy property on the cessation of the said state of war. However, the Sunil Kumar judgment had further narrowed down the time during which a property could be legally vested in the government. It emphasized that under Rule 182(1)(b), an appropriate vesting order was required, and it referred to a notification issued on 3rd December 1965 by the Governor of East Pakistan to be the only order of vesting issued under Rule 182(1)(b). As such, the court held that the only criteria for determining whether a particular property is a vested property or not is to see whether it was an enemy property on 3rd December 1965 and not on any subsequent date. However, this has in fact convoluted the earlier observation of the court, because one side is playing cricket, one side is playing checkers. The concerned notification of 3rd December was clothed in general language confirming the overall power of the provincial government to take over enemy properties throughout the continuance of emergency. In order to actually vest a particular property to the custodian, it was only practical that some more specific administrative order or notification existed. Nevertheless, this particular explanation of the Sunil Kumar decision was not adopted by the subsequent judgments, with few exceptions. The later judicial trend followed a clearer interpretation by holding that it is throughout the emergency period, that is 65 through 1969, that a property could have been vested lawfully in the Pakistan government as enemy property and not beyond that. Next part discusses continuance of the enemy property laws in the independent Bangladesh. lo and behold. Hot TV, what you are saying, I have heard of those things from certain people. I have not read anything on those on that topic. On 10th April 1971, the Provisional Government of Bangladesh was formed and the Proclamation of Independence was issued. By the Proclamation of Independence, the elected representatives of the People's Republic of Bangladesh declared and constituted Bangladesh to be a sovereign people's republic in order to ensure for the people of Bangladesh equality, human dignity, and social justice. All the buzzwords and word salads and uh, word noodles, word soups that you can come up with to get funding from India and UN. On the same day, the law's continuance enforcement order was issued, which declared that all laws that were in force in Bangladesh on 25th March 1971 shall, subject to the proclamation of independence, continue to be so in force with such consequential changes as may be necessary on account of the creation of the sovereign independent state of Bangladesh for like 5 minutes. Thus, in order for Ordinance 1 of 1969 to continue in force in independent Bangladesh, it needed to be consistent with the spirit of the Proclamation of Independence. Clearly, from that perspective, Ordinance 1 of 1969 remained ineffective in the newly created Bangladesh. Its basic premise was the 1965 war between India and Pakistan, and Bangladesh, having established itself through the War of Independence against Pakistan, was not clearly engaged in any war with India, and properties of Indian nationals could not be retained by the Bangladeshi government under the pretext of enemy property. क्योंकि भोसले के हम तो enemy थे ही नहीं उनके. At least we thought so. Hence, it was only natural and in accord with norms of international relations, things that no one gives a shit about in Bangladesh, that the properties that Bangladesh had received as enemy properties from the Pakistan government would be returned back to their original owners, be they Indian nationals or their Bangladeshi successors. However, the question of Indian property, the question of enemy property, seemed to have failed to attract the attention of the state leaders in a post-war country faced with difficult challenges of rebuilding the nation. Similar to how people forgot that Savarkar ko jail mein dala tha to prevent the assassination of लियाकत अली खान और some other Pakistani. ऐसे ही अच्छा लगा, डाल दिया जेल में, फिर भूल गए. The government circulars issued immediately after independence, nevertheless, did throw some light on the practicalities surrounding enemy properties in the new territory of Bangladesh. In an administrative letter dated 6 January 1972, addressed to the Deputy Custodian of Enemy Properties, the additional Deputy Custodian addressed the problem of returnees whose properties were once declared as enemy properties. After independence of Bangladesh, many such owners were returning back claiming ownership of over their properties. The letter acknowledged that to deal with the claims of numerous returnees, it was important that a proper scheme for restoring those properties be framed, and hence the additional deputy custodian was requested to issue necessary instructions on the same. In answer to this, the deputy custodian issued a circular on 1st February 1972 affirming that as there was no policy for restoring the properties vested as enemy properties till that date, the law relating to administration of enemy property, that is Ordinance 1 of 1969, was continuing in force by virtue of the law's Continuance Enforcement Order 1971. As the instruction itself suggested, this continuation of the Ordinance 1 of 1969 was merely for the purpose of administration of enemy properties. भाई समझ लो, एक जमींदार का कोई अच्छा बगीचा वाला बिल्डिंग है, उसमें भोसरी के क्या एडमिनिस्टर करना पड़ रहा है? तुम जाके क्या घास काट रहे थे या फिर वहां पे marijuana के पौधे उगा रहे थे? what administration did you have to do? As the instruction itself suggested, this continuance of the Ordinance 1 of 1969 was merely for the purpose of administration of enemy properties, and it did not encourage new enlisting of enemy properties. This circular had importantly mentioned that the government was soon to formulate a policy for restoration of enemy properties to the original owners, and pending such policy, status quo should be maintained so that no one could illegally occupy enemy properties. The instruction further specified that, according to the new policy, properties would be restored to the returnees by cancelling the existing leases if there were no legal difficulties to that effect. It was even suggested that if such cancellation was not legally possible, Alternative accommodation arrangements should be made for the returnees till the expiry of the term of the lease. Thus, the subsisting rights of the original owners over their properties were clearly acknowledged. Subsequently, in 1972, the Bangladesh Vesting of Property and Assets Order PO 29 of 1972 was promulgated, which should have ended all speculations regarding the continuance of the 1969 ordinance in the independent Bangladesh, although, as will be discussed later on, it failed to do so. By this order, all properties situated in the former East Pakistan, which had previously belonged to the Pakistan government, became vested in the government of Bangladesh, including properties that were quote unquote vested in or managed by any board constituted by or under any law with effect from 26 March 1971. Thus, amongst other properties, the enemy properties that were vested in the custodian under Rule 182(1)(b) of the Defense of Pakistan rules became vested in the government of Bangladesh in the same right with which the properties were initially vested in the Pakistan government, that is, without exhausting the title of the original owners. Thus, even if it could be assumed that despite being inconsistent with the proclamation of independence, कि भाई ऐसा इंडिपेंडेंस लिया है भोसरी वालों ने कि जिस देश से इंडिपेंडेंस लिया उस देश का जो एनिमी है, जो एनिमी बोलने का लॉ है, वो लॉ भी रिटेन करते हैं. नॉट ओनली इज इट द लॉ ऑफ योर एलिजिड ऑप्रेसर्स, इट इज ऑल्सो द लॉ दैट कॉल्स द सेम पीपल एनिमीज whom your oppressors also called enemies. तो अब जिन लोगों के पास थोड़ा बहुत दिमाग है वो लोग बोलते हैं कि द एनिमी ऑफ माई एनिमी इज माई फ्रेंड. ये जो अब 4D चेस वाले जीनियसेस है बांग्लादेश में, उनको लगा कि द एनिमी ऑफ माई एनिमी इज ऑल्सो माई एनिमी. Thus, even if it could be assumed that despite being inconsistent with the proclamation of independence, the Ordinance 1 of 1969 continued in Bangladesh, it was officially made inoperative by PO 29 of 1972. With this, the properties that were taken over under the former enemy property laws became vested properties under the administrative control of the Bangladesh government. As the law was clear on this subject, the next plausible step for the government was to formulate a policy, as indicated in memo number 74 EP 4/72, to restore the properties to their rightful claimants. However, no such policy had been formulated for restoring the enemy turned vested properties to their rightful owners. Lol. There are two straightforward reasons justifying such restoration. First, when the properties had vested in the Pakistan government, they were vested for a limited purpose and without extinguishing altogether the title of the owners. As the Bangladesh government had no larger right over those properties than that of the Pakistan government, it is only natural that it should initiate restoration of those properties once the immediate purpose of vesting had been served. Secondly, even if it could be assumed that there was no obligation on the Pakistan government to restore the properties taken as enemy property, that could not free the Bangladesh government from this obligation, as the owners of such properties could never be legally considered as enemies of the newly independent Bangladesh, which had a very different alignment with India. Therefore, and Indian government, nor did Kolkata's intellectuals ever give a shit about this, that at least notice who is being called enemy officially, legally in their country. Therefore, a clear obligation lay upon Bangladesh after its emergence as an independent sovereign to return the enemy turned vested properties to their original owners. It could not assume full ownership over those properties, let alone add new properties to the existing list of enemy properties. However, a number of administrative circulars issued after the 1972 order indicate that this aspect of the very nature of enemy turned vested properties was not properly realized or appreciated at the government level. Oh, I wonder why. The term enemy property was still being used, and the provisions of the 1966 order, 6 years after independence. So, and the provisions of the 1966 order relating to administration, disposal of enemy property were being followed, as if that law were still continuing in Bangladesh. The circular dated 24th October 1972 is particularly significant as it stated in clear terms that the process of detecting and taking over possession of enemy properties would continue as before under the same authority given in Article 5 of the 1966 order. However, this circular was brought in the context that in detecting and taking over possession of such enemy properties, Occupants were facing harassment without having proper examination of their claims. Hence, permission was required to be taken from the additional custodian of enemy properties before any such order under Article 5 of the 1966 order could be passed. It appears that there was confusion and misinterpretation surrounding the laws of enemy turned vested properties during the period immediately after independence. Oh, अच्छा अच्छा ऐसी गलती से हो गया. Steps for restoring the properties to their original owners were also not taken by the ruling Awami League government, which was considered to be the protagonist of promoting a secular Bengali nationality. With the change of government in 1975, the suffering of the Hindu minority over issues of enemy property laws naturally aggravated. The succeeding military regimes, which leaned towards a more Islamized model of nationality, were naturally less sympathetic towards the grievances of the Hindu owners who had lost their ancestral properties as a result of the continuation of the enemy property laws. Rather, new policies were adopted which allowed government agents to encroach upon properties belonging to Hindu owners. Although a restoration policy was not formulated by the first Awami League government, further enactments concerning enemy properties were brought closer to the end of the regime. These enactments were first the Enemy Property Continuance of Energy Provisions Repeal Act 1974, and secondly, the Vested and Non-Resident Property Administration Act 1974. The Ordinance 1 of 1969 was repealed by the first act hereinafter the from now on is going to be called in this paper at least by the name of the Repeal Act. So was repealed by the first act hereinafter the Repeal Act, which provided in section 3 that, quote, all enemy property vested in the custodian of enemy property appointed under the provisions of the Defense of Pakistan rules continued in force by the said ordinance, Ordinance 1 of 1969, shall vest in the government of Bangladesh, end quote. Lol. ये है भोसले के इनका इंडिपेंडेंस का नमूना. The Repeal Act simply vested the properties in the government without making any provisions for their management or administration. Hence, the second act hereinafter, the Vested and the Non-Resident Act, was promulgated. अब से इस पेपर में इसको बोला जाएगा Vested and Non-Resident Act. Okay, so hence the second act, the Vested and Non-Resident Act, was promulgated to provide for such provisions of administration of enemy properties. However, passing of these legislations have been rightly criticized as being a result of, quote unquote, confusion of thought and misconception on the part of the legislative department of the new state of Bangladesh. Lo and behold, yes, obviously, because the judges and some scholars like Abdul Barkat and Dr. Taslima Yasmin are playing cricket, while everyone else in Bangladesh is playing checkers. And the Hindus of Bangladesh are in the audience, of course. They are not even playing the game. The 1969 ordinance, having become ineffective by virtue of the Laws Continuance Enforcement Order 1971, and all enemy properties having been vested in Bangladesh, Bangladesh government under PO 29 of 1972, Public Order 29 of 1972, there was no question of need of revesting the same properties to the same authority. This vesting of enemy properties again in the government had only increased the confusion surrounding this issue and had reopened the scope to cast doubt on whether the 1969 ordinance did continue in Bangladesh till 1974. However, despite the failure to introduce any restoration policy or a strict guideline to restrain new identification of enemy properties further down the road, the intention of the lawmakers during the period after independence seemed to have been not to quench rights of the original owners. This intention was evident from the Vested and Non-Resident Act of 1974, which clearly stated that the properties that were vested in the government under Section 3 of the Repeal Act would be under the management of a committee, and that committee could take only such measures in respect of the property as was necessary for its good management and protection. Management. It further provided that the committee was not entitled to transfer any vested property otherwise than by monthly or annual lease, and in case of permanent transfer, the committee had to obtain written consent from the owner. These provisions clearly expressed that the properties vested under the Repeal Act in the Bangladesh government had so vested for the limited purpose of protecting such properties, and the rights of the original owners were not lapsed by such vesting. Acha. Also, the administrative circulars issued right after the enactment of the Repeal Act give an impression that by repealing the 1969 ordinance, what the ruling government intended was to remove doubts, although unsuccessfully, surrounding the continuity of the said ordinance in Bangladesh. It intended to officially put an end to the fresh enlistment of enemy property as well as to the ensuing suffering of the Hindu owners. Thus, the circular number 51L dated 20th January 1975, issued by the Ministry of Law and Parliamentary Affairs, stated in clear terms that, quote, the properties declared as enemy property after the promulgation of the Act XLV, I'm sorry, I've forgotten Roman numerals. What is XLV? So anyway, Act XLV, unfortunately, I'm going to have to just say XLV. X is 10, L I've forgotten, V is 55, so I guess 25 maybe, or no, not 25. I don't remember at all. Shit. So promulgation of the Act XLV of 1974, the Repeal Act, should at once be released to the owners with compliance report to the ministry. End quote. This was re-emphasized in a number of circulars that were issued by the government subsequently on the same subject. Now, the 1976 Amendment Ordinance, another effort at playing the character of a fake country, playing the character of a country, changing the entire complexion. 76. This positive stream of administrative and legislative actions with regard to the enemy properties had abruptly changed its route with the beginning of the subsequent martial law regimes following the assassination of Sheikh Mujib. In 1976, the Vested and Non-Resident Property Administration Repeal Ordinance number XC2, again I've forgotten Roman numerals, XC2 of 1976 was brought about, which repealed the Vested and Non-Resident Act. Along with this came the Enemy Property Continuance of Emergency Provisions Repeal Amendment Ordinance of 1976, Ordinance number XC3 of 1976, which in fact triggered the state-sponsored illegalities under the guise of enemy properties. This ordinance brought an amendment to Section 3 of the Repeal Act of 1974 by way of adding that the properties would not only vest upon the government would also have the authority to administer, control, manage, and dispose of such properties. It was observed in a subsequent appellate division judgment that by this amendment, the entire complexion was changed, and the government had become the ultimate authority to dispose of the properties in any manner, as if the rights of the original owner had elapsed. However, with due respect to the judgment, it can be argued that this does not appear to be a sound interpretation of the law. The main purpose of the Repeal Act cannot be changed by merely adding some ornamental expressions to the original provision by a subsequent amendment. Also, as Section 3 was amended after repealing the Vested and Non-Resident Act, it could very well imply that Section 3 incorporated the same authority with regard to enemy properties as was given under the repealed Vested and Non-Resident Act. Now, as already discussed, the Vested and Non-Resident Act had the authority to administer the enemy properties, which also included the disposal of the property when necessary, only to protect the same, allegedly. In fact, since no management committee as contemplated in the Vested and Non-Resident Act had ever been constituted, it can be rightly argued that all this time the government had the implicit authority to manage and protect the vested properties, keeping in view the subsisting title of the owners of such properties which were in a state of temporary suspension. By the amendment to Section 3, that implicit authority had been merely expressed by using certain generalized terms. Hence, by adding the words administer, control, manage, and dispose of, legally no new authority had accrued to the government, and the overall purpose of vesting such properties remained the same, that is, to manage and protect them. Moreover, a proposition that the rights of the original owners had been fully lapsed by the amendment to Section 3 might have some relevance had there been an explicit reference in the amending provision stating that from 1976 onwards, the government would assume full ownership over vested properties and all rights of the original owners were to be extinguished. No such express reference had ever been used in the laws relating to management of enemy-turned vested properties, and such an interpretation would not perhaps be a correct exposition of the law. Now, Abirzen, you are obviously describing a dark situation in your neighborhood. If push does come to shove, and you end up interacting with those people, just remember to tell them at least one thing. First of all, play this live stream for them, and secondly, tell them that we are coming. We are coming for the entire country. It's just a matter of time. No one will get away with these things. The entire state, the state with capital S, won't exist in a few decades. And whatever these people in your neighborhood would do in the on the pretext of searches, all that will be paid back to them in the coming decades, or in the maybe coming few months or years, who knows. But it's going to come to them. Remind them this. Although legally there could not be any change of complexion by the 1976 amendment, as observed in Rahim Akhtar case, in practice, this expression, in fact, aptly described the dramatic change in the government policies that took place as a result of this amendment. Immediately after this amendment, by an administrative order dated 17th April 1976, the circular number 51L, dated 20th January 1975, which had ordered release of any property taken over by the government after the Repeal Act of 1974, was annulled. The 1976 circular stated in clear terms that the government had the authority to take over possession of enemy properties even after the Repeal Act of 1974, and in support of this authority, the circular referred to the Appellate Division decision of Bangladesh Enemy Property Management Board versus Abdul Majid. However, the judgment was misquoted in this circular as having held that, quote, if any property could appropriately be taken over as enemy property under the former enemy property laws, but was not taken over as such at that time, there would be no bar in taking over possession of such properties even after the enactment of the Repeal Act of 1974. Holy shit! What the fuck? Did you all just hear this statement? This is insane shit. Check this out. If any property could appropriately be taken over as enemy property under the former enemy property laws when Bangladesh was in Pakistan, but was not taken over as such at that time, there would be no bar in taking over possession of such properties even after the enactment of the repeal of the Enemy Properties Act of 1974. What did I tell you just half an hour back or 1 hour back? Exactly that is being described here. That situation, that लॉ भोसरी के फॉलो करना है नहीं, इनका चुतिया कॉन्स्टिट्यूशन हर कुछ महीने में चेंज होगा, हर 4 साल में कोई नया डिक्टेटर आके बोलेगा द इंडिपेंडेंस डे अब है, अब से इंडिपेंडेंस डे, अब मैं चलाऊंगा देश, ये फेक देश जो कि कुछ सालों में भारतवर्ष वापस जाएगा. एंड in between they pay a bunch of highly educated lawyers to come up with this bullshit justifications and these terminologies, these lexicons and these statements. क्या जरूरत है ये सब का? ये सब पैसे तुम अपने गरीब लोगों पर इन्वेस्ट करो ताकि वो उन लोगों को भारतवर्ष जैसे राइजिंग इनकम इनक्वालिटी एंड राइजिंग इस्लामोफोबिया के देश में ना आने पड़े. ओके, ना आना पड़े. तो सिर्फ सुबह उठ के बोलो हिंदुओं को मारो भोसरी के और उनका जमीन हड़प लो, ये बोल के काम खत्म करो. इतना इतना काहे इतना लॉ वॉ मरवाना है? तुमको दिखाना है कि तुमको लॉ आता है. तुमको बाहर इंग्लैंड में जाके जब किसी को इम्प्रेस करने की कोशिश करोगे तब जाके बोलोगे आई एम अ लॉयर इन बांग्लादेश एक्चुअली यू सी. ও না এটা তো কলকাতার উচ্চারণ, ওয়েস্ট বেঙ্গল বোর্ডের উচ্চারণ. দে উইল প্রবাবলি সে নমস্কার বন্ধুরা, আমি বাংলাদেশ থেকে আইছি, আমি লয়ার হইছি. Will probably say this in the prisons of in the prisons of England as well. So what's the point? What's the point of this all? This appellate तो एक लॉ में है कि लेट्स से एक्स भोसरी वाला है, एक लॉ में है कि तुम इसको भोसरी वाला नहीं बोल सकते हो. थर्ड लॉ बोल रहा है कि अगर पहले लॉ में उसको भोसरी वाला बोलने का परमिशन था मगर भोसरी वाला नहीं बोला, तो अब तुम उसको भोसरी वाला बोल सकते हो इवन दो द लॉ इन द मिडिल सेज कि तुम अब भोसरी वाला नहीं बोल सकते हो. क्या क्या अजीब मदरचोद. आई एम फॉरगेटिंग माय गालीज इवन. व्हाट द फक. This is the most insane law I've ever read about. As examined before, drawing on a so this appellate division judgment, however, had a completely different finding. As examined before, drawing on a vesting order which was passed in 1970, the appellate division held that in order to declare a property as enemy property at the date of the order of vesting, a state of war between India and Pakistan must have existed, and the owner must have migrated to India before that date. Acha, so you see that creates a bit of a problem in declaring India uh, an enemy of Bangladesh by declaring war on Bangladesh. Of course, that can be handled because unless China actively supports Bangladesh, there's by no magic can Bangladesh ever win a war against India. US supported Pakistan forever as much as they could legally. Even then, Pakistan could not ever defeat an Indian army. तो उनका ये लो न्यूट्रिशन चूतिया क्या करेंगे? Indeed, the analogy that can be drawn from this is that after independence of Bangladesh, no new properties can be vested as enemy property, as there is absolutely no question of existence of any war after independence of Bangladesh. As such, it does raise a question as to the legality of the order itself. Karthik Sutradhar is saying, I don't make videos about anything first and foremost. I discuss papers only these days. But make a video about them in what sense? I have discussed papers on them. I have discussed how Professor John Money completely fabricated his research on alleged transgenderism, and he was later exposed as a fraud. But by then, the narrative had become so mainstream in Western academia that everyone just goes along with it now, even though it's the idea of transgenderism is based on completely fraudulent research by John Money. As such, it does raise a question as to the legality of the order itself. Subsequent to this circular from 1976 onwards, the government not only started disposing of enemy properties to interested classes, but to make the situation worse, new properties were being enlisted as enemy properties. In 1977, the government issued a circular which provided detailed guidelines on how to carry on such disposal and new enlistment of enemy properties. The circular allowed long-term lease of vacant non-agricultural lands to any deserving persons, keeping it within the discretion of the land officials to decide who would be chosen as a deserving candidate. And this opens up room for rent seeking. For the few rich landowning upper caste Bengali Hindus who do by chance end up meeting a Muslim politician who maybe does not spend his entire day hating Hindus, he can go about his way, do some shenanigans, and keep his property. More significantly, this order gave Tahsildars, land officers at the lowest tier of land administration, almost absolute authority over dealing with such enemy properties, and also encouraged them to find and take over the so-called concealed vested property by making provisions for rewards. Thus, ample opportunity was created to allow the land of officials to resort to corrupt and unfair practices in disposing of the enemy properties and detecting new properties in that category without providing any proper monitoring system or strict guidelines. हाँ, बाबू को बाबू गाइडलाइन देगा, ये है वो मॉनिटरिंग का घपला socialist idea. Obviously, the main victims of such abuse of authority were Bangladeshi Hindu owners whose properties provided an easier excuse to the land officers to have it detected as enemy property on the ground that the owners had once migrated to India in 1965 or that their legal heirs had died. Unfortunately, although there were a number of judgments from the apex court declaring such actions to be unlawful, meaning from the Supreme Court of Bangladesh, this practice continued for a long time with patronization from the influential land grabbers acting in collusion with the corrupt government officials. To take an example of such blatant misuse of authority, in Bokul Rani versus Bangladesh, the court's findings revealed that the application for granting lease of property was accepted long before the property was declared as enemy property, and on the very day when the property was declared as enemy, the Hindu owners were evicted from that land and the applicant of the lease was inducted into possession. Now, what does this remind you guys of? The old viewers, okay, people who have been following this channel for more than 1.5 years or about 2.5 years, 2 years, okay. You all will remember we discussed a research paper on the Hindu exodus of Hindu Nepalis as well as other kinds of Indians and Hindus from Bhutan. These are the exact kinds of shenanigans they did in Bhutan as well. Abhay, yes, this is the only legally plausible, internationally plausible thing for to suggest even from a YouTube channel that uh, all Hindus of a country of Bangladesh shift to one specific state if there's enough religious and political organization convincing you all to do this. It can be possible, but this is a factor. At least one state where Hindus are the majority. एक state at least ऐसा बनाओ. More so, the same applicant was granted the lease 1 year after getting into possession. Okay, encroachment of property rights continued. Abhijan is saying, um my message to all Hindus of Bengal, Assam, Tripura, Northeast have. Uh, no, you see, Abirjan, we can't have that because there are school shootings in USA because of their mental health drugs and their 192-year-old law, which apparently is giving side effects only 10 years back. You see, that's why we can't have arms in our homes, you know. क्योंकि ठीक जैसे अब्बा नहीं मानेंगे, ठीक वैसे ही हमारे हिंदुत्ववादी सोशलिस्ट नहीं मानेंगे. As noted earlier, this policy of encroaching upon citizens' property rights in the name of taking over enemy property continued even till recent years. Oh, yeah. So, RS is saying, yes, me and however, yeah, I remember. That was an insane paper as well. As noted earlier, this policy of encroaching upon citizens' property rights in the name of taking over enemy property continued even till recent years. From 1982 onwards, during Lieutenant General Arshad's regime, disposing of enemy properties continued with the same vigor without making any distinction as to whether such properties were taken over by the Pakistan government or by the Bangladesh government after independence. On 17th July 1983, a cabinet decision was issued which ordered speedy disposal of all enemy-turned vested properties by the month of December of that year. By this time, the question of restoring the enemy-turned vested properties to their original owners had become almost a forgotten issue. Instead, their immediate disposal was treated with utmost priority. Following this cabinet decision, a detailed instruction was issued by the Board of Land Administration on speedy disposal of enemy properties, which reinforced the authority of the union and distinct level land officers to further, quote unquote, identify, detect, and declare properties which were to be vested to the government. However, amidst protest against such arbitrary policies, in a conference held on 31st July 1984, General Irshad promised the representatives of the Hindu community that the government would stay all proceedings relating to disposal and new enlistment of vested properties. Accordingly, on 23rd November 1984, by an administrative order, all such proceedings were stayed from the date of 21st November 1984. However, this pledge was not materialized subsequently. However, however, take a shot of vodka or green tea every time I say however in papers discussing these topics, okay? This is that same however again. I'll take a shot of tea here. However, nice things were planned, good things were about to happen. However, this pledge was not materialized subsequently, and new enlistment of vested properties continued as usual. This was particularly highlighted in a subsequent government circular on 6th August 1988, which had appropriately described the prevailing unfair practices surrounding vested properties. It stated that despite the president's clear order, new properties were being declared and taken over as vested properties, and properties merely included in the vested property register of 1967 were being acquired without any proper hearing or investigation. It further noted that many Hindu families were being forcefully evicted from their properties without giving them any opportunity to prove their title on ownership. Rohan and Abhay, remember exactly what was done to Hindu Nepalis in Bhutan. So guys, new viewers, do check out our live stream playlist. The playlist is called the playlist that this video is also going to be a part of that. It's called Papers and Article Discussions. Okay. There you will find a research paper we had discussed many months back where the Hindu exodus of Bhutan was discussed. Hence, the circular ordered that all proposals relating to eviction from vested properties had to be first submitted to the Deputy Commissioner, and such eviction would only take place if the Deputy Commissioner was fully satisfied as to its legality. Further, the circular re emphasized that after the declaration made by the President, no new vested property case could be started. Although the circular clearly provided a more sensible interpretation of the laws, in practice, the property rights of citizens, specifically of Hindu minority citizens, were still facing challenges. With the change of regime in 1991, when a democratic government was reinstalled under the BNP, the administration of vested properties again took a new turn. Unfortunately, instead of requiring the properties to be returned to their rightful owners, the need to keep the properties under government's effective control was again prioritized. In a circular dated 8th June 1993, the government's concern was expressed over losing possession of many vested properties and noting the loss of income that resulted thereby. It was worded in a language as if those properties had always belonged to the government, and keeping such properties within the control of the government was necessary only for the profits arising out of such properties, without thereby being any question of returning them to the rightful claimants. भोसरी के कौन चूतिया rightful claimant है? हाँ, हमको तो यहाँ पे administer करना है rightfully. Again, in a circular dated 4th November 1993, vested property committees were formed at the district level to examine and amend the existing census list of vested properties. This circular yet again made provisions for concealed vested properties and required the committee to inform the government on any such finding. Thus, the illegal vesting of properties of Hindu owners was enticed once again by the administrative actions of the government authorities. The Vested Property Return Act 2001. The next significant transition in the law of enemy turned vested property took place in 2001 during the last year of the Awami League regime, which came into power by winning the national elections in 1996. Repealing the vested property laws was one of the important election manifestos for Awami League in the 1996 election, and hence, before the next election was due, it was imperative on the ruling party to take a tangible step towards fulfilling that promise. And 2001, remember, people must never forget what happened in 2001. Another genocide of Hindus happened. Much gang rapes of Hindu women and Hindu children happened, especially if they were associated remotely with the Awami League, which is allegedly a bit less anti-Hindu than everyone else. Hardly so in terms of their policies. Maybe in terms of lip service, they are a little less anti-Hindu. But 12-year-old Bengali Hindu girl in a remote village, who is apparently a polling agent of Awami League, gets gang raped by BNP supporters after Awami League gets defeated. And when all is lost and nothing can be done anymore, the mother of that girl simply pleads to the people who are about to rape her daughter that please at least don't go all in at once. One by one, go into that room to rape my daughter. On 3rd September, now some Android wannabe fuckers have come to the comment section and responded to the previous time I talked about this and said that, oh, only Bengalis can do this. Anyone else would have fought or preferred that their daughters die. You fucking idiots. If you think that way, I feel sorry for your kids. If you think any fucking thing is preferable than your son or daughter staying alive, you don't have any business becoming a parent ever. On 3rd September 2000, the then Prime Minister Sheikh Hasina, in a regular meeting of the Cabinet of Ministers, took the decision to return the vested properties to their original owners. Now, of course, killing their daughters would be absolutely non-indefensible, but the idea that the woman could have fought a little more, yes, as if she had not tried everything else, okay? Imagine the situation accurately. She tried to run, she tried to fight, all her defenses were broken down. At that moment, if she risks her life further to protect her 12-year-old daughter, what happens then to the 12-year-old daughter, what all things happen to her, and what all things happen to her for the rest of her life. At least she lives alive, lives to tell the tale. Yeah, it could have been so that the girl could be kidnapped anyway, which was not done just out of the benevolence of the rapist, of course. Two words you never hear in a sentence. But why should she die, uh, or die fighting for a daughter whom she might just be able to protect for the rest of her life? Okay, so parenthood is not a place for macho shenanigans. You have to prepare for those situations in other ways, for the on the other days, on the day of that battle, on the day of, or at least when the Titanic has sunk. You can't pretend to be a superhero. Anushka and Shomiti, that was not said by commie feminist women. It was said by proud Hindutwadis. In order to materialize this decision, a 5-member cabinet committee was formed to formulate a draft law for restoration of ownership of the vested property, which submitted the final draft of the Vested Property Return Act on October 22nd, 2000. On 8th January 2001, the cabinet approved the draft of the Vested Property Return Bill 2001 as recommended and amended by the cabinet committee. The bill was placed before the National Parliament on 29th March 2001, and on 11th April 2001, the Bangladesh Parliament passed the Vested Property Return Act 2001. However, another shot of however, although the law was initially successful in consoling the sufferers of the enemy property laws with its apparently favorable features, the unnecessarily complicated provisions for restoring possession, clogged with lengthy procedures, could not bring the positive change it had promised. Okay. Abhay, that is an interesting point, or at least a pretty good point. But you see, the main point that any feminist commie or stupid Hindutwadi who's saying those things is missing the core point, because they are of course also thinking about Johar when they're saying those things as a counter to me. No, but you see, Johar is fucking voluntary. It's consensual. महिला खुद जाके कूद रही है आग में. यहाँ पे गांडू बोल रहा है कि मम्मी को चाहिए था, उचित था अपने डॉटर को मार देना to prevent her from getting raped. Okay, as if her rest of her life is not important. That one night of absolute evil defines the rest of her life, her entire existence. तो and without her consent. Okay, voluntary भी नहीं है. Oh yes, Abhay, yes. Two arguments. Why didn't they pick up arms? If they were such great Bhairava worshippers, why didn't they get saved by their spirituality? That's why I like that conversation of Rajashi Nandi in that channel. Okay, in that channel, which is by the name of Ranveer Allahabadia's app. Okay, I forgot what's the name. Whatever his app's name is, उस नाम से एक यूट्यूब चैनल भी है जहाँ पे राजेश नंदी 2 बार गए हैं और 2-3 बार गए हैं. The very first time he went there, the very first episode, there he clarified 2 brilliant things. One is this idea of commie women again, or feminists, that first, sometimes they say Hinduism is so regressive that we did sati pratha, etc. On the other hand, Hinduism is so progressive that we have so many goddesses that every woman is a reincarnation, or is a manifestation of those goddesses, or Shakti. And then how can India have any rapes or any violence against women at all if we have such great goddesses in our culture? Okay. Now, both those arguments are insane. But Rajesh Nandi clarifies that, Are bhai, no woman is inherently divine, unless to the extent that everything has some divinity in every bit of their molecules and stuff. But if every woman is the Swarup of Shakti or Ma Durga or Ma Kali, so every man is a Swarup of Shiva and Ram or what? So, ठीक है, so we expect now that since Hinduism is India is a land of devout Hindus, So there should not be any crime at all against any man from any woman, because we, lo and behold, guys, we are the manifestations of Lord Shiva and Lord Ram. तो हमारे अगेंस्ट तुम कुछ नहीं कर सकते. तो भाई ऐसे ऐसे आर्ग्यूमेंट से तो नहीं चलता है. बट द अदर थिंग दैट राजेश नंदी क्लैरिफाइड वाज दैट स्पिरिचुअलिटी से या फिर वो भैरव उपासना से सब कुछ नहीं होता है. यू आर सपोज टू एम्बॉडी दोज वैल्यूज इन योर माइंड, and you are not supposed to shut your fucking brain down, and you're not supposed to, let's say, believe in fairy tales and miracles and magic. Okay, check this out. कितना एक्सटेंट तक हिंदुइज्म का क्रिश्चियनाइजेशन हुआ है, इस एक एग्जांपल से तुम लोगों को पता चलेगा. ठीक है, लेट मी पॉइंट आउट अ नाइस सेट ऑफ डिफरेंसेस बिटवीन टू स्कूल्स ऑफ थॉट, एंड you'll see when we talk about morality these days, or when we say that Nietzsche was religion and therefore Hindutvadis should not also listen to Nietzsche, etc. The morality Nietzsche was critiquing was Christian morality. The morality a lot of Hindus today believe in is Christian morality. Now check out this thing. I'm taking an online course in philosophy, modern philosophy as well as postmodern philosophy. I have not gone to the postmodern philosophy part as of yet, of course. So in modern philosophy, Thomas Aquinas, the first guy to reconcile pagan Greek mythology with Christianity, after this, broad divisions come up between the Greco-Roman way of thinking and the Judeo-Christian way of thinking. I don't know how fair it is to call just Judeo, but include Judeo here, but a lot of these things today at least don't apply that much to Jews. So maybe at some point, I don't know that much about Judaism. So anyway, the Judeo-Christian world versus the Greco-Roman world, okay? 5 key differences. You'll notice the 5 points that are in favor of Greco-Roman absolutely apply to how Hinduism operated, how Hindu society operated in India in ancient times, and how you see today the things that I'm going to describe for Judeo-Christian values today applies for Hinduism, which is wrong. Okay, Greco-Roman naturalism, observing, building philosophies based on nature, versus Judeo-Christian belief on or focus in the supernatural. Supernaturalism versus naturalism. Okay, for example, Nietzsche once said that there's more philosophy in a human body than there is in any philosophy book in the world. What have our texts said? Our great geniuses, rishis said, Jatha pinde tatha brahmande. Jatha brahmande tatha pinde. Whatever happens in your body happens in the universe. Okay. Today I was discussing this with a friend of mine. The anterior mid-cingulate cortex. Okay. A portion in your brain, like the prefrontal cortex, which is your wisdom decision-making part of the brain, which is here mysteriously where our third eye is allegedly is said to have existed or exists. Okay, that's the wisdom-making part of the body, which grows in men at around 25 years old and later, and in women just about when they are 24 or 25. So for which I believe no one should have voting rights before they are 25. But anyway, similarly, there's another section of the brain called anterior mid-cingulate cortex, which grows only and only when you do tough things. Okay? Tough things which you don't want to do, not just tough things which you don't want to do, which you know you have to do, and then if you end up doing it anyway, that's when that anterior mid-cingulate cortex grows. But you can say, who the fuck cares? Why should I grow that anterior mid-cingulate cortex? That anterior mid-cingulate cortex is the key to growing your will to live. Okay. If your anterior mid-cingulate cortex keeps on shrinking and shrinking because you never do anything that you don't want to do, you will just lose the will to live. And do I really need to come up with any specific quote? You know how fundamental this is a Hindu idea, right? That if it's tough, if it's got to be done, it's got to be done. Frankly, all religions end up saying it in some point in their lives, in some point of their life cycle. But even Hinduism does so. Because of our focus on nature, naturalism, things that actually happen in society, and we learn how the world occurs based on that. And when we accept this is another great quote I want to tell you all. This quote is from Francis Bacon. He said, it's a very famous quote actually, that nature must be obeyed in order to be commanded. If you don't even obey nature, which means if you don't even take nature for what it is, if you don't even accept nature, the functionings of nature, the Sanatan eternal principles of nature, the way they are, you can't command it. if you do command it, then you can, if you do obey it, then you can command it and actually run an anarcho-capitalist state or civilization like ancient India was. Now, when people come up with insane ideas that have absolutely no precedence or examples in nature by itself, that's when ideas that need large scale totalitarianism, authoritarianism, and centralization in order to survive in order for those ideas to survive, or in order to both as well as further those ideas everywhere else in the world, that's when those ideas get born. When people move away from the the naturalism aspect of things, uh, let's say inequality comes to mind, of course, the first and foremost example that should be in this conversation, that nothing is going on equally in nature, from effort to your upbringing, etc., or food, and therefore it really can't happen unless you tweak the scales to a large extent. And tweaking the scale to a large extent from the side of the state means you are going to create a dictatorship where you are going to end up killing a lot of people deliberately. So this is a slippery slope still, because we can go and fall over the cliff into the naturalistic fallacy landscape, because now just because something is natural we do only that. No, it's not about emulating nature literally in your daily life in the same way that thing occurs logistically in nature. It is your duty to learn or observe and contemplate and note the organizing principle, the philosophy, or whatever you can learn from the things operating in nature. Second, Greco-Roman characteristic: focus on reason. Judeo-Christian, focus on faith. भरोसा, भरोसा है मान लो. Greco-Roman, science. Judeo-Christian, dogma. And I'm not being taught these things by a commie atheist, okay? I'm being taught by these things by a person who is great friends with Jordan Peterson. And Jordan Peterson also agrees with these things, okay? So you see, there has been an evolution of apologetics even in Christianity up until even the recent times. It's actually basically going on at the hands of Jordan Peterson even today. Just a few days back, he called this guy, this professor, in his podcast. Greco-Roman proposes self-confidence. Judeo-Christian proposes helplessness. हमारा क्या होगा? Now only X can save us, or Sarkar can save us, or my Bap can save us, or Babu can save us. Fifth, Greco-Roman ideas focus on achievement. Judeo-Christian values focus on renunciation. Ascetic है, हम क्या है? हम तो गरीब आदमी है, फकीर आदमी है, झोला लेके निकल पड़ेंगे, पैसा क्या है, हाथ की मैल है, etc. So you see, repeatedly, Greco-Roman and Hinduism were similar. अब थोड़ा बहुत उन दोनों में इंटरेक्शन भी हुआ. अब प्रॉपर डॉक्यूमेंटेशन आज हम एग्जैक्टली प्रूव नहीं कर सकते हैं कि कौन सा आइडिया किसके साथ किसके पास ट्रेवल हुआ, मगर उन लोगों में इंटरेक्शन तो था ही. बट यू सी, आफ्टर दैट इन बिटवीन कम्स दीज आइडियाज of absolute baselessness, not rooted at all in reality or the eternal principles of nature or society or the universe. Supernaturalism, faith, dogma, helplessness, renunciation. It is not about blindly adopting nature, but also not about conquering it. It's about harmonizing it. My parents always say that कर्म है तो करना है, इच्छा है नहीं है का कोई नहीं. Yes, हमारे में प्रकृति को संस्कारित कर संस्कृत बनाते हैं, प्रकृति से लड़ते नहीं. Yes, क्योंकि तुम लड़ नहीं सकते. वही तुमको ओबे करना है. ओबे करके अब तुम जितना चाहे अकॉर्डिंगली तुम अपना जिंदगी बिताओ. क्योंकि it's not like we don't command it at all. Maybe we are talking about the same things but using different words. But let's say eating animals or killing any animals at all, okay? A lot of Christian morality Hindus who don't even follow the exact morality of Christianity, but have made up some mixed up morality for Hinduism, believe that Hindus basically should be like Jains, should not consume or kill any animals at all, and anyone who does that is a bad person. Okay, now I of course support that view, but it's remotely sustainable today at least. But first and foremost, it has to start from by boycotting those products, etc. But how is that supposed to operate in the ancient times? Now that's when having too much faith in unnatural things and implausible things leads you to lie and manipulate and try centralization and try dictatorships, because then those people with Hindus with Christian moralities go on saying that Indians, no Hindus ever ate meat. That's the argument they go to. So I would say when you kill any animal, you are commanding nature. भाई तुम उसका गला काट रहे हो, वो तड़प के कुछ सेकंड हो, तड़प के खून बह के मर जा रहा है, इसमें कहाँ चूतिया हारमोनी है? वो हारमोनी बोल सकते हैं, हाँ तो मतलब अगर वो नहीं, मैं उसको नहीं खाता, मैं भी मर जाता, एक्सेट्रा, मे बी हारमोनी इन दैट सेंस. I prefer to call this commanding. But first you are obeying the nature at least. That's where uh, the problem comes, that you don't even fathom the general eternal principles of nature. Adibhan, my stance on Pashu Bali is that I don't personally support it. I will never eat any what's the correct term, balified animal ever. I don't give any Hindu gyan on it, because mainly because the entire fucking country is eating meat anyway. Everyone who complains about Bali Pratha is eating meat. Only and only the the 1,100 maybe vegans that are there in the country are the only ones who have any right to complain about Bali Pratha, not the rest of the 1 crore 130 crore people in the country. And in an ideal scenario, if everyone, at least most people who live in climates where vegetarianism is possible, do become vegetarians, and even then Bali Pratha goes on, that's kind of sustainable. I would still like it not to happen. I have other arguments, but I just don't rake up useless bullshit, which is that, you see, first and foremost, that goat is not spending an entire lifetime in a cage like our factory raised animals do these days, like all or poultry raised birds and all. So one fine morning you catch a goat and you kill it, versus the rest of the society, rest of the year, on the rest of the occasions, not consuming any meat. That would be pretty ideal. Okay, so if that goat was going to die of old age anyway, what was the death going to be like for him or her? He was going to go about limping. He's going to be attacked by other carnivorous animals and stuff. कुछ ना कुछ खराबी होता उसके साथ वैसे भी. तो चलो एक दिन में एक काट लिया हमारा कुछ, अगर किसी का कुछ फेथ है विदाउट एनी एक्सपीरियंशियल अंडरस्टैंडिंग, फेथ है तो कुछ लोग तो ये भी लिबर्टेरियन का कभी आर्ग्यूमेंट नहीं हो सकता है कि नहीं, हम तुमको हर वो चीज मानना पड़ेगा और समझना पड़ेगा और जानना पड़ेगा जो मुझे मानना, जो मैं मानता हूँ और जानता हूँ. तो अगर किसी का है भी फेथ कि वो बलि देने से बढ़िया कुछ होने वाला है उसके जिंदगी में या आसपास में, ऐसे सिचुएशन में जहां पे सारे के सारे वेजिटेरियन है, वहां पे इट्स चलो कर लो, एक इतना छोटा सा नंबर है तो क्या है. The other argument I have is that see, people think there is some dichotomy or divide or contradiction between materialistic understanding of rituals versus the ritualistic understanding of rituals. I don't see it that way. Rene Girard, one of my favorite philosophers, he has written a book called, is the book here, it's called violence and sacred and the profane, no, sacred and the profane is something else, sacredness, scapegoat and violence, ऐसा कुछ नाम है बुक का. ठीक है, मैंने वो बुक इतने दिन से नहीं पढ़ा है कि मैं नाम भूल चुका हूँ. Let me see, where is the book? Yes, so this is the book where he discusses the recurring theme of scapegoats in every society, violence and the sacred. Okay, this is the book. So his argument is that every society looks for a scapegoat in a way to do collective murder, legitimized collective murder and legitimized collective violence in a controlled situation. So it's sort of controlled chaos. Whereas if a situation doesn't do any of those things, if a society is forced to be gotten rid of their violent, um, let's say, instincts completely, 100%, then that society does not even have any survival instincts in a way. So every society, knowingly, unknowingly, subconsciously, because of some spiritual or religious reasoning justification, comes up with some scapegoat mechanism. एंड ये नाम लिटरली स्केपगोट है ही इसलिए क्योंकि अकेला हिंदुओं को आइडिया या गोट मारने का ऐसा नहीं है, गोट ही मारा जाता है, तो स्केप गोट ही नाम है उसका. तो एंड व्हेन दैट लेजिटिमाइज्ड कंट्रोल्ड एनवायरनमेंट में एक एक अनलीशिंग एंड लेटिंग गो ऑफ दोज वायलेंट इंस्टिंक्ट्स हो गया, and then everyone goes home happy. Okay, yes, we are kind of in touch with our past, let's say, violent instincts. Okay, I'm saying that इसके लिए बलि प्रथा जरूरी हो सकता है, और मेरे ख्याल से इसीलिए बलि प्रथा शुरू हुआ है इंडिया में भी, और हर जगह में ही बलि प्रथा इसीलिए शुरू होता है. बट even keeping the religious reasonings intact, we can interpret it to be something other than a goat these days. Since there are religious reasonings and justifications to kill cut a goddamn watermelon instead of a goat from legitimate tantra sources, why not cut some other kind of living being who maybe is going to be killed anyway, like criminals who have gotten capital punishment, etc. Why not shift it to them? As a society, we are going to kill them anyway. Why kill an innocent goat at that point? But all these things are insanely problematically hypothetical, because at that moment there is absolutely almost basically no argument against Pashubali that can come across as legitimate, because the entire fucking country is high on meat. So it's a pointless discussion to have. Okay. The BNP and its Islamist allies passed an amendment to the act allowing the government unlimited time. Okay, let's check it from let's do a bit of a recap. However, although the law was initially successful in consoling the sufferers of the enemy property laws with its apparently favorable features, the unnecessarily complicated provisions for restoring possession, clogged with lengthy procedures, could not bring the positive change it had promised. The scheme of the act was further diluted under the BNP-led coalition government in 2002. The BNP and its Islamist allies passed an amendment to the act allowing the government unlimited time to publish the list of returnable properties by amending the previous provision which had required the government to publish the list within 180 days. Thus, the law was made virtually non-existent by this amendment. During the subsequent Awami League regime, which came into power for the second term, a number of further amendments had been brought to the act in response to the plea of the minority rights activists. However, these amendments had mostly dealt with procedural issues without touching upon the real question of legality or effectiveness of the entire process. The law as it stands at present is deeply flawed, and there has not been any effective return of the enemy properties till date. Besides providing an overtly complicated procedure for returning, the 2001 Act had also contained a number of features which cast doubt on the apparently good intention of the lawmakers in returning the properties to their original owners. To begin with, the official Bengali title of the Act, as well as its preamble, use the word "prottarpon" to mean return. According to the ordinary dictionary meaning, the word "prottarpon" refers to an act of giving, offering, committing, bestowing, or awarding. The title and the preamble had deliberately avoided using common terms such as restoration of possession, or release, which were being used in the previous official documents relating to the subject, and instead used the term prottarpan, which was perhaps a new terminology rarely used in land related documents in Bangladesh. The term, in effect, gives an impression that the government is actually favoring certain persons by giving away some rights which had lawfully belonged to itself. Although this statement might arguably find some rationalization in the case of properties that were vested upon the Bangladesh government by virtue of Public Order 29 of 1972, originally taken over by the Pakistan government, the same cannot be true in case of properties which were taken over by the Bangladesh government at various times after independence. All such actions of the government after independence lacked any legal justification. The government cannot bestow or award property over which it does not have any lawful right, and the title of the act does therefore throw a doubt on the real intention of the lawmakers. This doubt is further intensified by certain other provisions of the 2001 Act. First, the Act defines what laws are to be included under the term vested property laws and lists all the major laws that had dealt with the enemy property issues since the Pakistan period, including the Defense of Pakistan Ordinance and rules up to the two acts of 1974, together with the 1976 amendments. The Act, however, has made a distinction between properties that are to be termed as vested property and those to be called as returnable properties. Thus, although the Act is titled Return of the Vested Property, not all vested properties were to be returned. According to the Act, vested properties were those properties which had vested upon the government under the vested property laws. As such, legally, any property that were vested after the vesting order of 1972 cannot be termed as vested property, as none of the vested property laws mentioned in the Act, which were passed after the 1972 order, authorized in effect any new vesting of property. क्या mental gymnastics है, genius 4D chess. Similarly, the term returnable property has been defined by the Act as those properties which had been enlisted by the government as vested properties under the vested property laws and which were under the possession or control of government immediately before the promulgation of the Act. Although a proper legal interpretation of this provision would again refer back to the same proposition that any property enlisted after the order of 1972 cannot be termed as returnable property, it was never interpreted as such. And in fact, the real intention of the drafters was to include all properties that have been under the possession of the government as being, quote unquote, vested properties. It did not make any distinction as to whether the returnable properties were vested upon the government before or after the 1972 order. Hence, properties that were taken over by the Pakistan government as being enemy properties and properties the owners of which were most illegally ousted from their possession during the period subsequent to independence, both have fallen under the same criteria of returnable properties. And the deprived owners, for no fault of their own, had to go through a series of hurdles with no guarantee of actual return of their properties. Another significant purpose of this act is to clearly exclude a large number of properties from being enlisted as returnable properties under Section 6. According to this section, properties that had been permanently disposed of or leased out by the government to any organization or individual cannot be returned. Thus, the act, which apparently promised to redress the grievances of those whose properties were illegally taken by the government, had in effect legalized all the permanent disposal of those properties over which the government had never acquired any lawful title. In 2012, by an amendment, a new provision was inserted in this act, according to which two lists of returnable properties, Schedule A and Schedule B, were prepared by the government. Schedule A was the list of properties that fell within the definition of returnable properties, and Schedule B was said to be those properties which were not under the direct possession of the government. Due to massive irregularities in preparing Schedule B, which triggered the protests from different activist groups, Schedule B was repealed by a further amendment in 2013, and the properties that had been enlisted under the schedule were required to be released forthwith. Accordingly, a simple instruction was issued from the Land Ministry as to the release of properties enlisted under Schedule B, which basically instructed the land offices to resume ordinary land administration process in respect of the enlisted lands, for example, accepting land development tax, etc., on showing legal documents of title. Although this simple process of release could be adopted in the case of properties under Schedule B, for properties listed under Schedule A, this option was not at all considered. Rather, return, quote unquote, return was made subject to an extremely detailed procedure. The entire process of hearing an application for return of vested properties under the 2001 Act was clogged with so many provisions that it is almost like a civil suit for declaration of title. Separate vested property tribunals have been created for hearing these claims, and submitting original documents of title is only the first stage of their process. The procedure requires even a hearing of witnesses from both sides. Interviews with a number of judges from the vested property tribunals for the purpose of this study revealed that it usually takes more than three quarters of 3 to 4 years to get a decree of return, and that also is subject to appeal to the vested property appellate tribunals. Even when a decree has been passed for return of the property to the owner, the file would go to the office of the deputy commissioner, who would then take steps to execute the decree. According to the interviewees, although there had been a number of decisions in favor of return of properties, the owners could not get back their actual possession as the files were being held at the office of the deputy commissioners. Thus, although the act was passed in 2001, till date none of the properties enlisted under Schedule A have been reported to have been actually returned to its owner. Now, um, one interesting thing is that the only copyright strike I have in my channel is for discussing another paper about this Enemy Properties Act that I had discussed again like 2 years back, written by a foreign-based Bangladeshi Hindu scholar. His name was Shaha, probably, as far as I remember. So Brill, the famous Brill publications, they hit me with a copyright, and uh, it was my insane stupidity that I did not check my mail, or did not even check the notification where it says that it's got a copyright strike. And so I disputed it after the time was up. But just to calm down my nerves, I mailed them anyway and said that I didn't say why the fuck, but in my mind I was saying, why the fuck did you give a copyright strike on this? I was just discussing a research paper of yours. I gave the original link to your paper. I named your paper repeatedly. It's not like I was claiming that I have written this paper. He said, whoever replied from Brill replied that no, it's a violation of copyright, etc. It's our paper you were discussing. You're not supposed to do it without permission. Even though before and after I have discussed countless papers from Brill, only for that they gave a copyright strike. Okay, because I was using credible, legitimate research from their own publication to describe the allegedly. I think this is the problem, that I was using their research to point out the problems Bangladeshi Hindus are facing. So when they respond by saying that okay, first of all, I had to mail about 7 times. Okay, I went on spamming them that why did you give a copyright strike, why did you give a copyright strike, why did you give a copyright strike, in different mails. 5-6 mails later, they say that it's a copyright violation, it's a copyright. So I said that, have you heard of the term called public sociology? How the fuck is this not public sociology? Legitimate scholars all over the world in sociology are discussing how to do public sociology better, how to reach our at least, let's say, spread our arguments further among the masses, how to interact with them, how not to just be cocooned up in our echo chambers. Many scholars themselves are saying these things. I'm doing you a fucking favor. I'm promoting your paper, your scholar, and saying that what a good, nice little journal this is, what a nice little piece of research this is, and I'm doing the public sociology on your fucking behalf, and you give me a copyright, you dumb fucking commie. फ्री मार्केट भी पता नहीं है, बांग्लादेशी हिंदुओं के बारे में बोलने भी नहीं देंगे, मादरचोद. Winnie the Pooh, our in-house powerlifter slash MMA fighter who does 90 kg bench presses and can fight anyone in the planet, is saying, always good to have meat, gotta hit daily protein 150 grams. That's not correct English, Winnie the Pooh. It's called got to hit daily protein 150 grams, not gotta. You are not from Bronx or Brooklyn. Anyway, you need 150 grams if you work out really well, and who knows how much you are working out. Otherwise, you are just having a very costly poop. Another notable flaw of this act is the absence of any process for the release of property from the published list of returnable properties. I get it now. Oh shit, I now get it. Why Winnie the Pooh is so emotional. Holy shit. all high IQ races, Chinese, Koreans, Japanese, are meat eaters. Yeah, and that's why we also keep on creating the best scholars and the biggest business owners and tax brackets all across the world without eating fucking dog meat. Imagine that. What a big mystery have we solved today. Anyway, why is Winnie the Pooh so emotional with his responses and his conclusions and his worldview? It's because he eats so much meat. He consumes 150 gram of meat or 150 grams of protein, most of which comes from meat allegedly, which means he is consuming insane amounts of estrogen that's given to those animals. Can you believe the amount of female hormones Winnie the Pooh has? Okay, if you right now, let's say, talk to him in a loud voice, if you come across him in an altercation on the streets and you say chup bhasri ke, he'll say why did you do this? I lift 90 kgs. That's how he's going to react. He's suffering from estrogen overdose. You can't consume 150 grams of protein from just meat sources without increasing your estrogen, because this guy's not hunting in the forests of Texas. Obviously he's hunting in the supermarket and having 50 rand tax a day. So you see, please pair him from today onwards. I didn't know he's consuming 150 grams of protein. This guy is stacked up on estrogen. Anyway, another notable flaw of this act is the absence of any process for the release of property from the published list of returnable properties. Rather, Section 7 clearly prohibits any application or civil suit against the inclusion of a property in the list of returnable properties. Thus, in case there has been any mistake or irregularity in preparing the list, the aggrieved persons are left with no remedies except for judicial review or constitutional challenge. Indeed, there had been a large number of instances where properties were mistakenly included in Schedule A. It even happened that the same properties were included in both the schedules at the same time or twice in the same schedule. Lol. This reminds me of Bhutan again. Most of the properties of Schedule A are recorded to have been so enlisted in the schedule at a date later than 1974. Whereas, as it had been already discussed, such inclusion is a complete nullity. The 2001 Act entirely ignored this important aspect and blatantly enlisted properties as returnable, including even those which were taken over in recent years. Enlistment of such properties as returnable was also in non-compliance with a number of judgments of both the Appellate Division and the High Court Division, which had declared new orders of vesting of properties under the repeal of the 1969 ordinance as illegal. Thus, it was held by the Appellate Division in Aroti Rani Paul versus Sudarshan Kumar Paul and others that, quote, since the law of enemy property itself died with the repeal of Ordinance Number 1 of 1969 on 23rd March 1974, no further vested property case can be started thereafter on the basis of the law which is already dead. End quote. मगर भाई एक पक्ष क्रिकेट खेल रहा है, एक पक्ष checkers खेल रहा है. A similar decision was also taken by the Apex Court, meaning Supreme Court, in Saju Hossain and others versus Bangladesh and another. Concluding remarks. In 1999, a parliamentary standing committee had prepared a draft law with a view to return possession of the enemy-turned vested properties to their original owners. However, in total disregard of that draft, the Cabinet Committee proposed a new draft in 2001, clothed in completely different language, which was ultimately genius for DHS, which was ultimately passed by the Parliament as the Vested Property Return Act of 2001. The differences between the two drafts point towards a deliberate effort of the policymakers to overcomplicate a law which could otherwise be drafted in a simpler language, providing for a clearer mechanism to address the issue. The very title of the 1999 draft, the Vested Property Restoration of Possession Act 1999, instead of using terms like prottarpon, suffice to show a positive intention of the drafting members of the standing committee to effectively return those properties to their lawful owners. The draft of 1999 was a brilliantly crafted law, which had truly appreciated the multidimensional complexities of enemy property laws and had realized the need of redressing those citizens who had been suffering most unjustly under the pretext of such laws. The 1999 draft stated unambiguously that any property which had been taken over after 16 February 1969, when emergency was revoked and Defense of Pakistan Ordinance and rules ceased to have effect, or which had been taken over before that date but were not under the possession of the government, will not be regarded as vested property. Thus, this draft had specifically excluded any property taken over after the revocation of emergency in 1969 from falling within the purview of the Act. It further provided that upon coming to effect of the Act, all title, interest, and possession of the original owners over such properties would be immediately restored. It did not specify the details of how that restoration would occur, leaving it upon the ordinary process of land administration system. If the present 2000 Act had incorporated this draft, the properties that were taken unlawfully after independence of Bangladesh would be automatically released in favor of the rightful owners. Instead, introducing such expensive and prolonged finally bola hai, ye to main uske bhale ke liye bol raha tha 2 ghante se. Instead of introducing such expensive and prolonged process of returning the properties only confirms the doubts that the present Act of 2001, the only ray of hope, might have tricked the apparently bona fide intention of the government and made way for those beneficiaries whose interests would have been heavily prejudiced had there been a speedy and real restoration of enemy-turned vested properties to their real owners. To conclude, the problem of enemy property as it stands currently probably will exist for a prolonged period until the country returns to India, of course. Will exist for a prolonged period within the present legal and bureaucratic processes. Exactly, which is why we are saying it has to come back to India as just another state. Return of enemy properties to the real owners at this stage seems to be an almost unreachable goal, being entangled with so many complexities and uncertainties that have been deliberately created by political forces and state agencies to facilitate the unlawful demands of the influential land grabbers. The only plausible solution to this would be to create a stronger pressure group collectively within the representation from the civil society and rights movements to break the chain of illegality and injustice against the religious and ethnic minorities that is being endured and practiced in Bangladesh in the name of enemy-turned vested properties. Acknowledgements हमारे लिए important नहीं है. Whew. You see, this idea that our estrogen overdose, semi-transgender, impending transgender, trans woman, proud trans independent woman Winnie the Pooh was saying that you see Koreans and Chinese are have so much high IQ because of how much meat they eat, which involves a lot of dog meat as well. This is almost like, this is basically like believing in Ayurveda just because it used to work in 500 BC India. You can't operate on that, which actually proves that none of the meat IQ has reached his brain actually. But you see, the geography, the climate, all that factors into what kind of animal and what kind of vegetables you are consuming. So if the climate is less polluted in China and Korea, and the ways of processing that meat, ways of bringing up that animal is different in that country, you are not going to replicate that by just consuming that same animal here. For example, omega 3 or 6 is famously the best quality of omega that you can get is from salmons, allegedly. Now, where do salmons mainly live? Okay, the best healthy salmons who are going to give you that best quality omega live in fucking Japan. People are having salmons here grown in arsenic-filled Bengal ponds and thinking they are going to get Japan-like intelligence from that goddamn fish. Okay, so it doesn't operate on that way, operate on those things. Remember nearly 2 years ago when you used to share a story of how a converted nurse was trying to yeah, yes, you see, different products are supposed to give you different IQ, but they don't. Anyway, this was a dark paper to discuss. Avir Zen, if he's listening, good luck, and thank you everyone for watching this live stream. Good night. Bye bye.
श्रवरूढं महाभीमं गुणाद्रष्टाङ्गरप्रदम् अस्य युक्तं त्रिनेत्रं च कपालकर्णिकाकरां मुक्तकेशीं ललज्जयं पिबन्तीं रुधिरं चतुर्बाहु समायुक्तं वराभाय करं स्मरेत् चतुर्बाहु समायुक्तं वराभाय करं स्मरेत् काली काली